Well, good morning. Courts of Justice Committee will come to order, and the clerk will call the roll.
Mr. Chair, you have a quorum.
All right. Well, I want to welcome everybody. We have, as usual, a heavy docket, and hopefully we can make good progress today in rolling through a lot of bills. We have 35 bills on the docket. After today, should we handle all 35 of those, which is unrealistic, we would have 98 more bills in committee, and we have until Friday for more bills to be introduced. So we have a reasonably heavy workload. This morning, I want to tell the members of the committee on the desk is a sheet, perhaps to refresh your recollection. The composition of this committee is identical to the composition last year, and we have a number of bills that are similarly identical to bills that we considered last year. So this is not to suggest that there is I suppose, a Presbyterian predestination with respect to those bills, but simply to allow members some historical perspective, and it may be that the discussion and debate might be abbreviated with respect to some of those bills. We do also have judicial elections coming up tomorrow, and the first thing I would like to take up this morning is certification of candidates for election to their respective judicial positions. We interviewed candidates in December, and all but one of the members who were, but one of the judicial candidates who were scheduled for interviews were there. The one who was not there was ill. It was noticed. His reviews were good, and nobody showed up to speak in opposition to him. And it would be my suggestion that we take up the certification of these candidates in the block. I think that maybe there's a suggestion that one candidate be removed from the block, and we can deal with that if necessary later. Is that right? Right. I think there's been a request that Judge Cleveland from Botetourt be removed from the block. So, and give Senator Stewart an opportunity to weigh in on that. We still have until tomorrow to deal with that. Is there a motion to certify the candidates who were interviewed in December in a block, except for Cleveland? All right, it's been moved and seconded. All in favor signify by saying, well, let's open the roll.
Ayes 12, no 0.
All right, the candidates are certified and will be eligible for election tomorrow. Next, we've got a number of bills that need to be re-referred. First, Senate Bill 1130, Senator Locke's bill dealing with Memorandum of Understanding for school resource officers. Is there a motion? This needs to go to Education and Health. Is there a motion to that effect? Second. It's been moved and seconded. All in favor signify by saying aye. All opposed, that's re-referred. Next, Senate Bill 1321, Senator Hangers, deals with licensed family day homes, needs to be re-referred to Rehabilitation and Social Services. It's been moved and seconded that that be re-referred. All in favor signify by saying aye. All opposed. And third, Senate Bill 1563, Senator Lewis's, another memorandum of understanding bill that needs to go to Education and Health. Is there a motion to refer that? It's been moved and seconded. All in favor signify by saying aye. All right, that bill is re-referred. All right, now we have 32 bills on the docket. First sign up is Senator Cosgrove. Senator Cosgrove, what bill do you have?
Senate Bill 1047.
All right.
Mr. Chairman, y'all saw this.
And
Sorry.
Senator, this is on our list as one of the bills that was considered last year, dealing with sex offenders and emergency shelters. I want to give you an opportunity to address it. We did a couple of things to it last year that I think we probably are inclined to do, amendments we're probably inclined to make again this year, but we'll gladly hear you.
Thank you, Mr. Chairman. Yes, this is the same bill you heard last year. It's dealing with registered sex offenders who go to an emergency shelter during a time of emergency. Mr. Chairman, I know that this bill was heard last year, but I'm sure that y'all had visions and dreams, and the Archangel Gabriel probably called and told you this is a good idea this year. So
We thought it was a good idea last year, just with a couple of little tweaks to it.
that's true. And most of the tweaks were just fine from last year, Senator, except that I then and still believe that there needs to be some type of penalty if a person does not register in these shelters. And let me tell you the genesis behind this. We had several states of emergency this past year. We have shelters that are open up, which are normally schools. And I will tell you that the schools and the school board was actually very shocked that there wasn't a requirement as put forth in my bill last year. It just makes sense. There's really no malintent on this bill. I also have, for your information, our Commonwealth Attorney Nancy Parr and our Chief of Police Kelvin Wright. Now, it was their idea to bring this bill forward. This is not something I just dreamt up.
All right.
So if we could hear them, I would appreciate it.
Be
It will
happy to
brief.
hear. Morning,
Morning,
Ms.
Mr.
Parr.
Chair, members of the committee. As Senator Cosgrove said, I'm Nancy Parr, Commonwealth Attorney for the City of Chesapeake, and I am here on behalf of the City of Chesapeake. I also have with me today Carrie McCardle, who is a prosecutor in my office. She came last year. She is my prosecutor who was assigned to prosecute sex offenders who fail to register. And she has just an expertise of that entire work of statutes and laws. So I do have her here to answer any questions because she could much better answer them than I could.
Thank you, Ms. Parr. Anybody have any questions? Chief?
Good morning, Mr. Chairman.
Good to see you this morning. Thank you for making the trip.
It's not uncommon for us to, who reside in the coastal regions of the Commonwealth as a result of climatic events, being required to open and support emergency shelters in order to protect lives. It's a major responsibility, and we in law enforcement, who are typically in charge of securing security for the shelters, think it's wise and prudent that persons who are required to be on the state's sex offender registry notify law enforcement of their presence if they are availing themselves of the service. Clearly, when there is an emergency and requiring activation of emergency shelters to protect lives, amongst our goals and responsibilities to safely provide services to all who are seeking shelter. The intent of this legislation is not to deny anyone service or access. It simply requires people who are in sex offender registry to notify law enforcement that they are present. This will afford all parties a measure of enhanced security and for offenders to have special restrictions as results of being on the site.
Senator Sasslaw has a question for you.
Yes.
Have you arrested anybody for an incident at a shelter?
No, sir.
You have not.
No, sir.
You prosecuted anybody for an incident at the shelter?
No, sir.
No, Mr. Chair, no, Senator, we have not.
Sarah Edwards.
What drives this is that we know that there are some people who are on the sex offender registry who cannot go onto school property. However, you have the other event in the extreme that a event comes up and they need shelter. We cannot deny them service. So this affords them the ability to actually receive shelter just like anyone else.
Sarah Edwards.
That,
Can you turn your microphone on?
Event occurred.
All right. Good to see
I'm
you,
Jordan,
Ron.
representing both the city and the school board. Both have supported this, and one of the things that the chief mentioned, it maybe gotten glossed over, sex offenders are prohibited from coming on school property. So without this, they're in violation of law even by showing up at the shelter if the shelter's in school.
All right.
Thank you.
Okay. Do you have anybody else? Ms.
Ma'am,
Parr,
I'm
sure.
sorry. Mr. Chair, in response to the questions to the chief about has anybody been prosecuted or arrested and what precipitated this, if I recall correctly, it came because of incidents in other states where there were problems, and that Chesapeake, the chief thought, and I agree, that this would be a good step forward to prevent what had happened in other states. So we don't know that we anticipate a huge number of cases, but it would be something in place that we do not have in place, like I think it was Florida or New Orleans that had an issue, that this was a severe problem for them in their emergency shelter.
Sarah Norman.
Ms. Parr, before you leave, I appreciate maybe it has not been an issue in Chesapeake. Are you aware that it has been an issue in some other jurisdictions?
Yeah, okay. Thank you.
Mr. Chairman,
Sarah Saslaw.
where has it been an issue? What municipality?
Mr. Chair, I think Senator Norman is indicating it has been an issue in one of his jurisdictions.
It was an incident?
All right. Senator Cosgrove, you have anybody else?
Okay. Now, Mr. Chairman, this is just a.
Hang on, before you
Okay.
wrap up, let's hear from Ms. DeVoy.
You got it.
Not yet. Not yet.
Mr. Chairman, members of the committee, good morning. I'm Mary DeVoy. And yes, we did discuss this bill last year. The chief just said that the intent of this bill is not to ban anyone from the emergency shelters, but the way the verbiage is written this year, unlike last year, the shelter can decide to ban the registered offender and their family. I want to remind people that there are misdemeanor offenses on our registry. So those misdemeanor offenses are not banned from school property. So the sweeping claim that sex offenders are not allowed on school property is incorrect. The majority aren't, but not all. There are also juveniles on our registry. So if a juvenile comes to a registry, to an emergency shelter, and they are separated from their parent, they don't have a caretaker. There are also disabled and autistic people who are on the poverty line. They have very little money. They don't have gas to get out of town. They cannot afford a hotel. If there is,
Mary,
yes.
if my
Yes, sir.
crystal ball is accurate, I suspect that we are likely to entertain an amendment that would make it clear that people cannot be excluded from shelters. So if you.
That'd be great. And
if-
segregated into the sex offender corner.
If
Would be great.
you have other concerns
I
or
do.
issues, go ahead.
I do. So I actually have a few amendments, and that would be so that they cannot be denied, they will not be segregated from the family or friends that they arrived at the shelter with, and also that notification of this new law, because it has a misdemeanor penalty, would go out to the offenders. Now, in the past, I have been told that we can't do mass mailings to the people on the registry, that it would be too costly, that it's impossible. Well, you may not know this, but last July, the state police decided to do the first mass mailer in 11 years since I've been an advocate. They took Delegate Freitas's bill that changed the law retroactively, and within a 2-week period, they were able to mail out letters to everyone at a cost of $14,000. So it does not require a fiscal impact statement, so notification could be given to the folks on the registry if this does become law. I would prefer that it doesn't, but if it does, we must give the people notification that it's retroactive because it has a misdemeanor penalty.
All right, thank you.
Thank you.
Last year, we made 2 changes to this. The bill wound up making its way all the way through both chambers and failed to come to a consensus in conference. If we make the same changes this year, we've got a lot of time to think about it and talk about it. Senator Norman?
Excuse me.
Thank you, Mr. Chairman. I respectfully move that we conform Senate Bill 1047 to the way it was reported from committee last year, which had the exclusion and took the Class 1 misdemeanor out.
Is there a second?
Second.
All right, it's been moved and seconded to conform to the 2 changes last year. Any discussion of that?
I would just have a question, Mr. Chairman.
Senator Cosgrove?
If we take out the Class 1 misdemeanor, what is going to drive anybody to actually follow the law?
Well, you know, that's the committee's action. Been a suggestion that we make that amendment. And so, you know, I suspect that there's plenty of time to talk about that issue and others.
So we took out the misdemeanor and what else?
And we
There could be no
added
segregation.
a provision that says no person shall be denied entry into an emergency shelter solely on the basis of his status as a registered sex offender unless such entry is otherwise prohibited by law. All right. Before us is the motion to amend.
Second.
It's been moved and seconded. All in favor signify by saying aye. Aye. All opposed. That amendment is made. The bill is before us. All right, there's motion properly seconded to report the bill. The vote is open. All right, the bill is reported. Thank you very much.
Thank you, Mr. Chairman, members of the committee.
Next, Senator DeStaff. Senate Bill 1150.
Morning, members of the committee. So, Senate Bill
And
11.
This is a bill that I think we considered 2 years ago.
Yes, sir, in 2016. Went through the House, went through the Senate. Majority of this committee supported it in 2016.
Go ahead.
So what this bill does is it prevents magistrate shopping and also stops from an arrest warrant to be issued in a misdemeanor offense to a law enforcement officer that currently is on duty when the charge arises from something when he was in the performance of his duty on the basis of a complaint by a person other than the law enforcement officer, an animal control officer, by the authorization of the Commonwealth Attorney or law enforcement agency. The bill provides for the appointment of an attorney of the Commonwealth outside the jurisdiction if a conflict of interest exists for the attorney of the Commonwealth having jurisdiction. So a quick scenario on this that happened this past year, an officer initiated a stop of a suspected drug dealer. The car fled, striking several vehicles. The suspect then fled on foot. The officer was in pursuit. The officer caught up to the individual, had him down on the ground. The individual was elbowing back to elbow the police officer. The officer, with a closed fist, struck the individual, getting the individual to comply. The suspect was arrested. From there, the suspect basically shopped magistrates to find a magistrate that would bring the officer up on charges. In fact, a closed fist to the head is referred to as deadly force in the Commonwealth. There's a Supreme Court case on that. But from the officer's standpoint, and it does go against, in Virginia Beach Department policy, However, when you're getting elbowed to the head or an elbow strike is coming up, an elbow strike to the head or neck will knock you out just as quick as a fist to the head. The concern on this was the suspect drug dealer, who was later brought up on federal drug charges, magistrate shopped until he found one that would issue a warrant while the officer was on duty, taking that officer off the street. This isn't the first time this has come up. It's come up in other jurisdictions in Northern Virginia. And I have a few other people in support of it that wanted to testify as well.
Well, let's hear from your witnesses.
Thank you, sir.
Morning, Mr. Chairman.
Good morning.
Ladies and gentlemen, thank you. My name is Captain Sean Adams with the Virginia Beach Police Department. On behalf of Chief Jim Severa and the men and women of the Virginia Beach Police Department, we thank you for your time today and ask you to support the bill.
Thank
Happy
you
to
very
answer any
much.
questions. Thank you.
Next.
Good morning. Thank you for having me. My name is Brian Luciano. I am a Virginia Beach police officer. I've been a police officer for 22 years. I am also the president of the Virginia Beach Police Benevolent Association, which is the police union. And on behalf of the over 400 and nearly 500 officers that I represent, we ask that you consider this bill.
All right. Thank you. Chief?
Good morning, Chief Kelvin Wright, Chesapeake Police. We ask that you support this. When we have allegations of officer misconduct, those incidents are very thoroughly investigated. And someone going to one magistrate, not liking the magistrate's opinion, then going to another magistrate, it undermines our system. So we ask that you support this bill.
All right.
Good morning, Mr. Chair, members of the
morning.
committee. I am Holly Smith. I am the Commonwealth's Attorney for Gloucester. But here today on behalf of VACA, we ask that you support the bill.
Thank you.
Morning, Mr. Chairman, members of the committee. My name is Kevin Kerr. I'm the legislative chairman for the Fraternal Order of Police of Virginia. And on behalf of our over 7,000 members of law enforcement and the public that supports us, we ask you to support this legislation. Thank you.
Thank you, Mr. Carroll. Anybody else? Supreme Court.
Good morning. Doreen
Good
Dalton
morning.
from OES at the Supreme Court. No opposition to this bill, but it would be helpful if the phrase law enforcement officer was defined in the bill, or if it made reference to another statute that defines law enforcement officer.
Do you have a suggestion?
I do not, but I know there are other statutes in 19.2, the arrest chapter, that do define law enforcement.
Mr. Chairman, I have a question.
Senator Edwards.
Anybody. First of all, you have a magistrate whose job it is to see if there's probable cause, correct? Second, and he's a law enforcement officer, sort of. He's a judge, a judicial officer. Secondly, before any of these cases get prosecuted, a Commonwealth's attorney will be doing the prosecuting, right? And the prosecutor has discretion to decide this is not a case worth prosecuting, correct?
Correct. In this case, the Commonwealth attorney did refuse to prosecute.
What happened?
The officer was not prosecuted.
Well, so that solves the problem, doesn't it?
Well, you still had a drug dealer that magistrate shopped and took an officer off the street by having him arrested when he was on duty.
Any other questions?
Mr. Chair,
Senator Peterson.
I'm unfamiliar with this phrase magistrate shopping. Is that like going to Target? I mean, how does that work?
It's pretty easy. Basically, you go to one magistrate. If you don't like the outcome of what the magistrate is doing, you wait until another one comes on duty, then you go to another magistrate. If you don't like the outcome of that, then you go to a third magistrate or a fourth until you find one who's willing to issue a warrant for the charges that you're seeking.
All right, further question, Mr. Chair?
Senator Peterson.
You realize there's a cause of action called abusive process that specifically talks to that? So if someone goes to a magistrate, swears out a complaint against you for an improper purpose, you have an immediate cause of action under Virginia law.
And I don't think a convicted drug dealer who's in jail at the time cares whether he's convicted of another offense of magistrate shopping.
Okay, final further question, Mr. Chair.
Senator Peterson.
So I guess my hesitation is we have a magistrate that's basically a gatekeeper for issue of arrest warrants against every single person in the Commonwealth, including the governor, including you and me.
Correct.
But yet we're going to carve out one group of people and say, well, they can't issue an arrest warrant against law enforcement officers, even if the Commonwealth won't charge. Just you can't do it.
What we're saying here, if I may, Mr. Chairman, is we're saying that based on the complaint of a person other than a law enforcement officer, animal control officer, without prior authorization from the attorney of the Commonwealth or by a law enforcement agency. So we're saying that the common Joe can't swear it out without it going through a process first, while the officer is on duty. So if you're going to issue it, wait till he's off duty. But don't do it while he's currently on the streets and on duty.
Any other, Senator Norman? Senator Norman.
Mr. Chairman, I move the report.
All right, it's been moved and seconded the bill be reported. Any further discussion? Hearing none, the vote is open.
Ayes 9, noes 5.
Mr. Chairman, members of the committee, thank you very much.
Bill reports. Thank you. Senator Chase. I think we've got Senate Bill 1031.
All right. Thank you, Mr. Chairman and members of the committee. It's a Senate Bill 1031 relating to false information and hoax criminal activities. Under this bill, it would become a Class 1 misdemeanor for any person to knowingly engage in conduct with the intent to convey false or misleading information. In circumstances where such information may reasonably be believed and where such information indicates that an activity has taken, is taking, or will take place that would constitute a felony violation. And the bill raises the penalty to a Class 4 felony if such conduct results in death or serious bodily injury to another person. A violation of this bill constitutes a separate and distinct offense, and the bill does not apply to any person permitted, licensed, or otherwise authorized to produce or create artistic or cinematic productions while engaged in the performance of his duties.
Amanda, my understanding is there was a high-profile incident in Chesterfield that maybe this led to. You have somebody who
Absolutely. In fact, I have a
going to
couple.
speak
I have
to
a
that.
couple folks here.
All right.
I'll
Let's hear from them
Okay, sounds
and
good.
about the facts driving this bill.
Okay, I would like to first introduce our police chief, Chesterfield County, Jeff Katz.
All right. Chief, good to see you this morning. Thanks for being here.
Good to see you. Good morning. Yes, the incident that brought rise to this request for legislation was a hoax kidnapping that occurred at a Walmart in Midlothian, Virginia, in Chesterfield. Several individuals perpetrated a kidnapping. Of course, it was not an actual kidnapping. They did it in order to get famous on Instagram. We had recently started working a homicide investigation of a young man and had to take all of our personnel off of that case in order to work what we believe to be a homicide for more than 24 hours. And as you know, as you're working a homicide, those cases become cold very quickly. So the diversion of our resources from a homicide to a hoax kidnapping was certainly not appreciated by our personnel and by the community. When we came to know that the incident was a hoax, what we found out was that we really had no mechanism on which to charge the individuals. We were obviously disappointed by that, but we also heard from our community, and our community expressed a great deal of outrage. And so we felt that it was important to ask for this legislation.
Chief, thank you very much.
Thank you.
You have other witnesses?
I do. Yes, thank you.
Step right up.
I'd like to introduce Kevin Carroll, who's the former president of the Fraternal Order of Police and the current president of the Chesterfield Fraternal Order of Police.
I was one of those people that got diverted when that call for service came in, and it is it's an issue that we now have to deal with because of social media and because everyone has cell phones now. And so, you know, it's not something we had come up before, but now that someone can immediately post this and it creates a sense of urgency, so the officers now have to run and investigate this, which takes us away from serving the public in other ways.
All right.
So we support the legislation. Thank you.
Thank you very much. Next.
Mary Ann Curtin with Chesterfield County. This is a request to the Board of Supervisors, and we ask that you support the bill.
Thank you. Ms. Parr?
Mr. Chair, Nancy Parr, Commonwealth Attorney for the City of Chesapeake, and I am now here on behalf of the Virginia Association of Commonwealth Attorneys, and as an association, we support this bill.
Okay.
Mr. Chairman, I have a question now.
Senator Edwards?
Yeah, see, there is a federal law right on point. Any reason why you can't just call the United States Attorney's Office to handle this?
I'm going to ask, let's see, there, I know what you're talking about.
18 U.S.C. Section
Yes.
1038.
So my understanding of the federal law, you're talking about the criminal statute, borrows heavily from the federal law. That's actually where we initially got some of the language from 2004. It's 18 U.S. Code Section 1038. Is that what you're referring to? So the bill would not only ban the sort of fake abduction which occurred in Chesterfield, would also address certain situations that have been known as swatting, and which has been a problem in certain areas of the United States. And I know that Chief Katz came from Florida. They had a number of incidences pertaining to that. There are no current
My understanding
state
is
laws
there
on the
are
books.
a number of instances in swatting. I'd never heard of that, but it's
SWAT team.
creating a circumstance that is likely to cause the deployment of a SWAT team, and can be very dangerous, especially in situations where it's not warranted. My understanding is that there have been a couple of deaths attributed to those incidents. So I think that's a serious concern.
I guess my question, Mr. Chairman, maybe to the Commonwealth Attorney.
Well, and I suspect that there are just some in this room who feel like federal government doesn't pick up that baton reliably, and that we don't like deferring to the federal government on all matters.
Well, the question I have.
Ms. Parr?
Since it is a federal crime, is there any reason to make it a state crime as well?
Mr. Chair, Senator Edwards, I would endorse the statements made by the chair regarding the federal government. We have a good, close working relationship with our U.S. Attorney's Office, but they just cannot take as many of their cases as we would appreciate that they would take. I think the stats across the United States are like over 95% of the crimes are prosecuted in state courts, not in the federal courts. We have a lot of comparable offenses, including a lot of our drug charges, and we prosecute the vast majority of those cases. So we do need this because we cannot rely on the federal government to have the resources.
Mr. Chairman, I guess my
Senator
question
Edwards.
is this a widespread problem? How big of a problem is it? I guess that's my question.
Mr. Chair, Senator Edwards, I cannot say that I am aware. I was aware of what was happening in Chesterfield, and I am aware of events in other parts of the country. I don't know of any specifically. Okay. Well, my chief has one coming right out of Chesapeake, if you would like to hear about that, Mr. Chair. That's.
I would
Senator-
like to hear it.
Well, hang on. Let's defer for questions for a moment. Senator Norman.
Mr. Chairman, if I could ask Mr. Benjamin, does this Senate Bill 1031, does it replicate the federal statute exactly with?
Mr. Chairman, Senator Norman, I have not looked at the federal statute. I'm sorry.
Steve, no, that's all right. I think in our working group, we identified a couple of areas where perhaps this bill ought to be modified if it's going to advance. I think one of the areas deals with potential defenses, the artistic license. Steve, you have any thoughts and suggestions?
You're right, Mr. Chairman, that we identified a number of potential issues with the bill as drafted, but did draft an alternative if it's acceptable to the patron. Under current law, it is a Class 1 misdemeanor for any person to knowingly give a false report as to the commission of any crime. And that seemed like the natural vehicle to amend if it needed amending. And so consistent with the patrons bill, what might work would be to amend that statute, which is 18.2-461. Currently, that statute says it's unlawful, it's a Class 1 misdemeanor to knowingly give a false report as to the commission of any crime to any law enforcement official with the intent to mislead. We would then add a subdivision 2 that would read as follows. It would also be a Class 1 misdemeanor to knowingly and with the intent to mislead a law enforcement agency cause another to give a false report to any law enforcement official by publicly simulating a violation of Chapter 4 or Chapter 5, the same chapters in the current bill. And then it would move current Subdivision 2 to Subdivision 3. It adds a subdivision which captures the essence of the patrons bill.
Okay, I'm agreeable. Do you all have any objections? Let's go right ahead.
Mr. Chair, if I could, Mr. Benjamin, following that, in the proposed legislation, it also creates a, I guess it's a new Class 4 felony. So would that carry over to the new codes?
Mr. Chairman, Nancy, it would not. One of the concerns that we had with the present bill was that there was no requirement of foreseeability resulting possibly in unintended consequences. For example, if an officer were responding to a situation and another motorist ran a red light and killed or injured that officer, you then have the Class 4 felony that is imposed, and that might not be the patron's intent.
Right.
What we are suggesting is that this modest change might be an important and constructive step towards what you want to accomplish. And if there were a death or an injury, I think that perhaps existing statutes would kick in.
Okay, I'm agreeable.
And it may also make it a little bit easier for this to navigate the shoals of the Commonwealth's finances.
I think that would be great.
If it's
Thank
a
you.
misdemeanor, I gather it does not need to go to finance.
Excellent.
That would be a good thing.
That's correct, Mr. Chairman.
All right.
Thank you, Mr. Chairman.
So there is a suggestion to amend. Is there a motion to adopt Mr. Benjamin's suggested amendments?
So
It's been
moved.
moved and seconded. All in favor of the amendments signify by saying aye.
Aye.
All opposed? The amendments are adopted. Anybody wish to speak in opposition to the bill before we open the floor? All right, is there a motion on the bill?
So moved.
It's been moved and seconded the bill be reported. Record your votes. Very good.
Ayes 14, no zero.
Next, we've got Senate Bill 1052.
Yes, thank you, Mr. Chairman. Members of the committee, Senate Bill 1052, as it relates to body-worn cameras and the release of the recordings. This provides a procedure for a defendant to request the inspection and the copying or photographing of any body-worn camera recordings that are within the possession, custody, or control of the Commonwealth. The bill provides that the Commonwealth may designate any body-worn camera recording subject to disclosure as counsel-only material, and that any unlawful reproduction or dissemination of such designated recordings is punishable as a Class 1 misdemeanor.
Mr. Chair, I've got a question to staff. How does this differentiate from 1033, Senator Stanley's bill?
Well.
Mine's better.
Apparently, yeah.
Of course.
Yeah, this and Senate Bill 1033 deal with the same subject matter. Senator Stanley, you want to share the podium and address your bill or this one? I anticipate that these will merge at some point.
What's up, Greg? They are the exact same language. Looks to me like. I don't want to steal your thunder. Is yours different from mine?
That's a little bit.
Yeah, this is
Mr. Chairman, on my 1033, I have amendments based on discussions with the Virginia Supreme Court.
Mr. Chair.
Senator Deeds, Senator Peterson?
I just have a preliminary question. That is, I like this bill, but why wouldn't this be discoverable already as Brady material?
Well,
I'm
let's,
asking.
hold on just a second. All right,
So, Mr. Chairman, I would answer him.
let's,
That's my experience.
Senator Chase, can we suspend on your bill and take up Senate Bill
Absolutely.
1033 since it's the lower numbered bill? We've got a amendment in the nature of a substitute that's been distributed. Is there a motion to adopt that? It's been moved and seconded. All in favor signify by saying aye.
Aye.
All opposed. The amendment is before us. Senator Stanley, you want to address the amendment?
The amendment was our use of council-only material in describing what material may be withheld or provided only to council because of its sensitivities to a victim or a witness. And we had wanted, and the Supreme Court reminded us that we needed to stay consistent. And so where it says council-only material, it has now been replaced with restricted dissemination material, which is consistent with the code in other places. The second amendment is the striking of a child victim or witness. We had an age in there of 14 years or younger at the time of trial. That has been stricken. And that way it's just child victim, doesn't put an age 14 or younger. Then the third is found in subsection D under body work camera recordings, and all metadata associated with such recording shall be retained. The intent there was to make sure that law enforcement retained that for a period of time, for 2 years. That was not included in the original bill.
Does your bill require all body camera footage to be retained, or is it just certain body camera footage?
It is 2-year retention for all body-worn camera recordings that contain only traffic infractions, 3 or 4 misdemeanor, class 3 or 4 misdemeanors, 5 years for class 1 or 2s, 10 years from time recording of felony offenses and second-degree murder, and 100 years for first and second-degree murder, robbery, carjacking, and your highest level crimes.
Okay.
Now, to answer, Mr. Chairman, the question posed by Senator Peterson, one would think this is Brady material, but what I have experienced over and over, and this is no fault necessarily to the Commonwealth's attorney, is that they determine what part of that video they want to give you. So you then end up getting an edited version. And that, this requires the turning over of all the metadata and the body camera video to the defense, subject to a limitation where there is a real or a threat to a victim and or witness, and that threat is articulated by the Commonwealth's attorney. And then we have in there even a procedure, which we do in the new discovery rules, which allows for the defense counsel to make an application for that which has been restricted, to make a demonstration of why the redaction is necessary for the defense of the defendant, and then pursuant to a court's review or an agreement by counsel, that material is now what's then determined to be restricted dissemination material, is stamped like that, and even when the case is over, if such material has been provided to the defense counsel, at the end of that, that is turned back into the court and under seal.
All right. Before we hear from witnesses who want to speak to this, one of the things that came up in our discussion of this bill and work group was the fact that the new criminal discovery rules that Senator Stanley has been such a strong advocate for a number of years are set to take effect in July of this year. And this bill really addresses an issue that is going to be greatly impacted by the discovery rules. And we're talking about adopting this bill even before the discovery rules go into effect. And I think that there was some thought that while there's great merit to the principles and issues that are advanced in this bill, maybe it's a year premature, and that we ought to wait and see what transpires after the discovery rules go into effect. But those are just discussion points, and I thought that maybe the witnesses who want to address the bill can focus their comments and maybe factor that in.
Mr. Chairman, if I may just briefly on that issue alone, and look, part of my legal practice is as a criminal defense attorney. What I've found, and you know that I push the criminal defense reform as it pertains to discovery. The Supreme Court, through the Humphreys Commission, took it upon themselves to reform their rules, subject to 1 year delay. Chief Justice Don Lemons in his letter stated so that we, the General Assembly, could make proper appropriations for those Commonwealth Attorney's Office that may suffer a burden from now having to go through all the evidence and provide all the evidence. And let me say this, Mr. Chairman, I anticipate, and I put a budget amendment in there, so maybe our Finance Committee can look at that a little better for the Supreme Court. But more importantly, as we travel into the 21st century, we as a General Assembly need to be on our toes and make sure that we are keeping up, not falling behind, but keeping up to make sure that we have a safe and fair criminal justice system that ensures that those that are brought before the bar of justice are given the same rights and opportunities to defend themselves against the government which seeks to take away their liberty. And now it's body cameras. Next time it'll be drone cameras or something else. And we've got to keep up. So if we wait, people suffer and injustice carries on.
Senator Sasslaw.
I would say to Senator Stanley, we got some laws on the books that haven't even made it into the 20th century, much less the 21st.
Mr. Chairman, I'd answer the gentleman by saying I agree.
Senator Norman.
Based on Senator Saslaw's comments, I think there's some legislators that are trying to make that advancement.
I'm going to stand back here.
All right.
Senator Stanley, are you aware of any discussions that perhaps continuing the discovery rules and the criminal procedure for another year?
Mr. Chairman, I'd answer the gentleman by saying I know of discussions that I've had, and those discussions are trying to make sure that we implement the new discovery rules in the rules of the Virginia Supreme Court within the time frame prescribed by the Chief Justice. That the concern was, and I think we as a General Assembly have to look at this, is that for smaller counties and Commonwealth attorneys in those type areas, even in the area that I practice mainly, but I practice all over the state, they're already doing an open file policy. And maybe the caseload is a little less than when I go up to Fairfax and hang out with Senator Peterson, where the volume alone in Fairfax would require man-powers, man-hours. And so I can understand that they may need to dedicate certain expense for someone to go through everything and to be able to make provisions in accordance with the new rules. That's really the issue, is how the larger areas that aren't practicing open file policies can conform to what these rules are, and that would be the delay. I think what, if I may speak for the Chief Justice in our conversations, his concern is making sure that, that they would have appropriate funding so that they could make such a transition that wouldn't hold this up to where what we're trying to cure, Senator Norman, is this, that one Commonwealth's attorney has an open file policy, same case, let's say it's breaking and entering. One lives right to the rule.
I practice
it's
criminal
disparity.
law. I'm really familiar with it.
Right. It's the disparity we're trying to make now uniform, that each defendant gets the same type of discovery and justice, no matter what their zip code is.
Mr. Chairman.
Senator McDougal.
Senator Stanley, in Section D, I guess it's 6D, line 71, onto the next page. Am I reading that correct? It says recordings that contain traffic infractions or Class 1 or Class 2 misdemeanors. My experience with most cases as they go through court is they don't actually obtain video evidence of the criminal offense, but they do obtain evidence of conversations or actions after the criminal offense.
Correct.
So if we enacted it this way, all that could be deleted. If murder investigation where they went into the house, did an interview, that could be deleted under no reasons whatsoever because it didn't contain a video of the murder itself. Was that your intent? Because it seems this is written for the act itself, not for an investigation
of the act?
Mr. Chairman, I'd answer the gentleman by saying, no, that is not my intent. It was trying to capture all of it. You know, from the time that the body camera goes on to the time that the body camera is turned off. But I can tell you, Senator, that, you know, I've had cases, as I'm sure you probably have, where they've just gone and, you know, and the case is delayed over time, and the Sheriff's Department has just deleted it. And we're deprived of that very important information. When and look, we even see where body cameras or cameras in car, they will go in backwards. When they hit the lights, it goes on, and then it backdates all the way to the stop. Then that may transfer to the body camera. I mean, you want to keep the whole,
Mr.
the
Chairman.
whole of it.
Mr. Chairman, my point is that the language in D only talks about the specific criminal incident, and I don't think that that's what's most important in 95+% of these body-worn cameras. It's the investigation or collection of evidence arising out of the criminal incident.
Well, I think maybe Mr. Benjamin has a suggestion that would assist.
Mr. Chairman, Senator McDougall is right. I would suggest, for example, on line 74, that wherever you see that contain only, you replace those words with arising from.
Okay.
Steve, would that mean that the body cam footage from a patrol officer manning the perimeter or monitoring access to a crime scene, that would have to be preserved? So he's sitting at the end of the driveway of a house and is checking people in and out. He's got a body camera, and we've got to preserve all of that?
Yes.
Okay. All right. You want to move that amendment, Senator McDougall or Senator Stanley?
I'd move that amendment, and I appreciate Mr. Benjamin as being my helicopter parent.
Been moved and seconded. All in favor of that amendment signify by saying aye.
Aye.
All opposed? That amendment is adopted. All right, let's hear from the witnesses briefly.
Good morning, Senators. I'm Greg Collins. I'm the Commonwealth Attorney in the City of Colonial Heights. I was here with Senator Chase for her bill, which is very similar to Senator Stanley's bill. Some things you want to consider real quickly. One is the Library of Virginia. As you know, there's a retention schedule for all documents. Several states have excluded body cameras from being public documents. I think that's one of the things that Senator Stanley's bill addresses is the retention schedule for that. So you maybe want to look at the retention schedule, as Senator McDougall has said. It's very important to keep that. Another thing to think about is we've had these body cameras since 2014, which is longer, I think, almost than anyone here in the Commonwealth. We've been sued over them. We've got retention schedules in place. There's a lot that goes into it when you get down the line, approximately 5 years down the line. One of the things we found out was victims' rights are being affected. If police were to show up to your home, one of the senator's home, and just to do a wellness check, he rings the doorbell, he doesn't recognize your spouse, he asks for the name, date of birth, social security number. Of course, the address is already there, they give it to him, turns off his body camera, goes on his way. You would think that you'd be safe because no one's going to investigate that. However, 3 miles down the road, another police officer is arresting somebody. His mic is on. All that information your spouse just gave comes over that microphone onto the other defendant's video. And so without this kind of amendment, you ask why we should do it now. We need to do it now for the victims. Your information, your spouse's information, address, date of birth, social security number, is going to be released out into the public if you don't do something fairly quickly about this. So there is a victim's rights problem with this. Also with juveniles, we're not required to give out juvenile information plus their face. So we have to redact all of those juveniles that are on your body cam video. This would prevent that. We can give defense that information, and they can't disseminate that juvenile's information. So if you're looking to protect juveniles and innocent citizens, this bill is something you want to support, and you want to support fairly quickly to prevent that kind of information from getting out. And I would support that bill.
Okay.
Thank you.
Thank you. Next. Anybody want to speak in favor or in opposition?
Good morning, Doug Ramstor with the Virginia Association of Criminal Defense Lawyers. I was one of the folks who
who drafted this in the State Bars Committee that was put together with Judge Humphreys thing. I will say, in the discovery rules, the proposed discovery rules under 3A11, it specifically provides for the provision of tangible evidence, and it specifically includes recordings, which was a new term that we added in 3A11. So there is, and we intended that we're in the committee, I think, to encompass body-worn cameras. It isn't as specific, I think, as what Senator Stanley's bill is, but I think the new discovery rules provide for that. They provide for it to be treated as restricted dissemination material. They provide for protection for juveniles and witnesses, for it to be declared this sort of RDM underneath that. I do appreciate Senator Stanley's bill has some retention schedules in it and requirements to be kept, because the discovery rules were really meant to only put the defense and the prosecution on the same footing. That is, if the prosecution has these things, to make sure the defense has them as well, and not necessarily to maintain them for a specific amount of time in case someone needed them later on. So I think there are great parts to that. But I didn't want the court to think that the discovery rules didn't speak to body camera footage, because I think the addition of the provision for recordings does that in there. That was the intent of the committee when
Mr.
drafting
Chairman.
it.
Well, thank you very much. Senator McDougall.
Can you speak to the provisions about restricted material for counsel only? I mean, that, I guess, causes me some concern, and would like to know what the thought process behind it is.
Absolutely, and this was based loosely off of an Ohio discovery statute, which provides counsel-only material in the same way, and we adapted it for Virginia. It provides that information that there's a concern, and frankly, any discovery can be declared restricted dissemination material. And it can be done under one of two ways. The first is through agreement of the parties, which is, I think, what will happen most of the time. Restricted dissemination material generally means it's information that is provided to the defense. They can show it to the defendant. They can show it to the client. They cannot provide a copy to the client. They cannot distribute any copies outside of the defense team. It's maintained within the defense team. They can provide a copy to an expert, but that's it, and it can't go past that. So one way is through agreement of the parties. Anything can be declared restricted dissemination material. If they cannot agree, the parties cannot agree, then the prosecution can ask for anything to be labeled restricted dissemination material if it is involves a child victim, if it involves an ongoing criminal investigation, or it might harm some law enforcement technique, if it involves a victim witness issue, and that's laid out in the statute. And then the prosecution can file a certificate with the court certifying what basis it is that something should be restricted dissemination material. And they can do that then unilaterally. If the defense objects and thinks they haven't met the conditions for it to be declared as restricted dissemination material, they can go in front of the court and show good cause why it shouldn't be restricted dissemination material, and the judge can say whether or not they think it should be restricted to the defense or not. I think 95% of the times what we'll see is that the defense and the prosecution will agree that the thing should be restricted dissemination material. At the end of the case, if it has got that label on it, and that information will have to be kept separate in a file in some way and stamped that way, it has to be returned to the court under that label, under seal, only available to counsel under court order in the future that way. So it becomes protected information.
Mr. Chairman.
Senator McDougall.
And we just got this substitute, so I can't say that I've done anything but skim it right here. But do I see any in this draft, any of those specific designations? It looks like for any type of case, you could say it's restricted. I mean,
Yes.
I understand the situations where there's a juvenile victim, juvenile defendant, some of those specific situations, but this looks like it's for every case. We don't let that be the entry point into being called restricted. Was that the intent as well?
I will say first off, in any case, the parties can agree that something is restricted dissemination material. The only time that those specific factors come into is when counsel doesn't agree and the prosecution wants to seek to put the label on proactively on their own. Then those factors apply under it.
I suspect that this esoteric conversation will continue if this bill advances, inasmuch as this will wind up in Senator McDougall's subcommittee of the Committee on Finance. So I would suggest that we look at this as a matter of principle and decide whether, as a matter of policy, we want to advance this or not, and we can advance it to finance, where it's got to go. Next, if you want to step up and briefly address your support or opposition.
Good morning. My name is Patricia Watson. I'm Commonwealth Attorney
Good to
in
see you, Ms.
Emporia,
Watson.
Greensville. Good to see you, too. I'm here on behalf of VACA this morning, and we oppose this bill, and we oppose it for several reasons, but mainly I think as Senator Obenchain had talked about before, it's a bit premature at this point. We've got the new discovery rules coming, and part of the problem I think with this is it's codifying part of the new discovery rules, but it's not codifying all of the discovery rules, and I think we're going to get into some problems with that. Also, there's some definitional problems, which most have now just been fixed with the amendment, but I do want to make you aware that this will include the cameras that CIs are wearing. This isn't just a body-worn camera that the officers are wearing, so there could be some problems with that. I would also point out for some of the people who talked about worrying about disclosing it, we already have a duty to disclose. We already have a duty to turn over anything that's exculpatory, so that has not changed. I would also point out that there is going to be a huge fiscal impact for the retention policy. I'm sure, as you know, that there are many, many things that it's going to cost a lot to hold it this long, and I think that's something that needs to be talked about a little bit further.
It'll be talked about in another forum.
Thank you.
Thank you, Ms. Watson. Next.
Mr. Chairman, I'll be brief. On behalf of the Fraternal Order of Police, we support the legislation, and I do believe there will be some other discussions that may make it better.
All right, thank you very much. Yes, sir.
Yes, my name's Dave Hoopsick, and I'm speaking in opposition to the bill. I think Senator McDougal hit the nail on the head. When you label something council material only, that means the judge can suppress evidence. I don't pay for body cams to have somebody suppress that evidence. Both sides should have access to it.
So, and thank you for being here. Are you affiliated with an
I'm
organization or a
just a
citizen here
that-
speaking your mind?
Speaking my mind.
Well, thank you for being here. Appreciate that.
You're welcome.
All right.
Mr. Chairman?
Sir McDougal.
I know that this has a little bit of direction to go, but I guess my concern is making sure that there's a group of lawyers that are looking at this. I do think that which would be this committee, I do think that there are some very important points in here, but there's still some that are concerning to me. Those timeframe retention schedules, those will certainly have a cost to be discussed elsewhere, but the specifics of the access to information, I really do think that needs to be tightened up significantly before we would move something like this forward. I think it can be done. I just don't think it's quite yet done in the substitute.
Senator Norman.
Thank you, Mr. Chairman. With a little different perspective, I would hope if there's some kinks in it that they could be worked out in this committee before the Finance Committee looked at them. And I say that in fairness to both of the patrons, is that the decisions that are made in finance are not made exclusively by those who are attorneys or those who sit on the courts committee, and I just think the insight is more appropriate here.
All right, so first thing that we need to do, unless there are any further comments or questions, first thing we need to do is roll Senator Chase's bill into Senator Stanley's bill, list them both as co-patrons. It's been moved and seconded. All in favor signify by saying aye.
Aye.
All opposed. The bill is before us. The substitute is before us.
Have we made the amendments that,
We have, the substitute as amended is before us.
Mr. Chairman.
Senator McDougal.
I know this might not be the direction that you're thrilled with, but I'd ask that this go by for a day or two or a week to let everybody come together. I really feel pretty strongly you're going to create a lot of problems if we don't tighten up who has access to the information and how a court would make that determination. Because you're going to have, in addition to a lot of prosecutors not knowing which way to go, you're going to have a lot of defendants saying, I want access, and an attorney is going to find themselves in a peculiar situation because we didn't specify which direction to go. So
For a week or a year?
Well, I don't think procedurally we can do it for a year. So I think the only option would be a week.
Mr. Chairman, I'd answer on behalf of my co-patron here that I think the importance of this cannot be understated, so it is worth the opportunity to try to address the concerns of my seatmate, Senator McDougal.
With a couple of groans but no objection, this will go by for the week, and we won't have another substantive hearing on it.
Yes, sir.
Yeah, all right.
Thank you.
Next, I know that, and Senator Black, I know you're next on the list. We've got a conflict. Somebody needs to leave, and Senator Favola is here. Would you mind if we took Senator Favola and her group of bills before your bill? I think, Senator Favola, you have
Mr. Chairman, I ask that Senate Bill 1136 be withdrawn. And then I have two other bills.
You asking that that be stricken?
Stricken.
All right. Is there a motion to that effect?
So moved.
It's been moved and seconded. All in favor signify by saying aye. Aye. All opposed, that bill is stricken. Next.
Would you like me to do the death penalty first, Senate Bill 1137, or hate crimes?
Is that the one you need? All right, 1137.
Mr. Chairman and members of the committee, you have seen this bill in the past. What this bill does essentially is it says an individual with severe mental illness, and that is defined in lines 48 through 52, would not be eligible for the death penalty. This is really a sentencing bill. It doesn't say that the person would have to be ruled not guilty, but this is, it's a sentencing bill. The person would not be eligible for the death penalty. And I bring this bill to you because repeatedly the U.S. Supreme Court has issued.
If I can.
Yes.
Right now, it can be considered by a jury.
That is correct.
As to whether to apply the death penalty. This would preclude consideration and simply take death penalty off of the table.
That's correct.
Okay.
It's my understanding. The U.S. Supreme Court over time has issued decisions that really talk about culpability and the fact that the death penalty should only be applied when an individual has a full understanding of the nature of his actions and the consequences. For example, we've had Supreme Court rulings that would exempt our youth from the death penalty, and there was a recent Supreme Court ruling in, well, it was in 2002, it was Atkins versus Virginia that really exempted those with a fairly low IQ. The word used was with mental retardation from the death penalty. So I ask that this be considered in the context of how we as a society want to apply the death penalty and where we view our justice system and how we want to, again, implement justice in our society. I do have some speakers who are far more knowledgeable on this topic than I am, so I would like them to have an opportunity to speak.
Okay, well, Senator Favola, and we will certainly do that. There's a long line of speakers. You were not here at the beginning. I pointed out that we have exactly the same composition of the committee that we had last year. This is a bill that we're familiar with. We heard last year with respect intended to your speakers. I'm going to limit their time. And they may want to confer amongst themselves as to how best to use that 5 minutes that they're allocated because this has been here before. Last year, we passed the bill by with a letter to the Crime Commission. The Crime Commission did not have the bandwidth to take it up last year. So we will certainly listen to your speakers at this point.
Thank you, Mr. Chairman.
Senator Norman, first.
Just preemptively, I thought we killed all bills when cell phones went off. But having said that, I know that there's a lot of passion about this, but it would be my suggestion at the conclusion of it to, once again, send it to the Crime Commission to take a look at it.
All right. All right, step right up.
Hi, I'm Matthew Engel. I'm a criminal defense lawyer, a death penalty practitioner from Charlottesville, former professor of law at University of Virginia and Washington and Lee University. I just want to make a couple quick points about this bill, and if there are questions, I would address those. Procedurally, this is modeled exactly after the Adkins, the intellectual disability legislation that was enacted after the Adkins decision. The two main points that I would ask you to keep in mind are one, that this bill identifies a group of people who may not qualify for relief under the sanity provisions. This is a broader definition of serious mental illness than sanity. So there are going to be a group of people who may be found to be legally insane for their conduct, but exempt from the death penalty under this legislation. So there's a real need for it, and therefore we think that it's appropriate to pass this legislation. I don't know if there are procedural questions. I'd like to give other people a chance to talk unless there are.
Mr. Chairman?
Thank you.
Mr. Chairman?
Senator Edwards.
Yeah, the speaker is exactly right. You teach now at UVA Law School?
I'm not currently teaching, but until recently, yes, sir.
Okay. Mr. Chairman, there's a huge gap between insanity, which is really hard to prove, and mental retardation, which is a fairly clear standard, and of course, the youth, people under 18. And that's about it right now that prevents you from getting the death penalty. That's it. And so this is a huge gap that needs to be filled by severe mental illness, which is a fairly loose standard, but it'd be proven by, as I read the bill, be proven before a jury by expert witnesses or a judge if it's a judge alone case. And this is a whole category that has never really been dealt with by the courts, and it needs to be dealt with by this legislation. And as far as the Crime Commission is concerned, I'm sure they're busy doing a lot of other things, and I think we ought to go ahead and get this bill out and onto the floor. I think it's an important bill. Thank you, Mr. Chairman.
Isn't that so?
Isn't that so? And everything I just said, exactly right.
That is exactly right. And the only thing that I would add to it is that the sanity provisions are not enough protection, because we know that jurors are extremely skeptical of finding somebody not guilty by reason of insanity. There's the suggestion that they won't be punished for their conduct, that they'll simply be sent home. And so there's a real, it's an extraordinarily rare defense for very good reasons. But this bill would enable the courts to properly factor in a defendant's serious mental illness as a bar to the death penalty, even if that person might be responsible and should be, in fact, held responsible for the commission of the crime.
Mr. Chairman, further question. Isn't it true the insanity defense is extremely hard to prove?
Yes, it's almost never raised, and it's even more rarely found.
Okay, thank you.
Thank you.
Thanks. Yes, ma'am.
Good morning, Mr. Chairman. I'm Rhonda Thisson with NAMI Virginia, National Alliance on Mental Illness. There's been wonderful arguments made here. I would only point out that the Supreme Court has recognized two purposes for the death penalty: retribution and deterrence. And for this population of individuals, neither one of those is the case. Retribution for someone who doesn't fully understand the consequences or the nature of their actions, it's not justice. It doesn't serve the cause of justice. And with respect to deterrence, these folks have, disordered, confused, unreal thinking, and the possibility of the death penalty is not going to deter their behavior. So I would just suggest that this does not meet the cause of justice, and the American Bar Association has agreed with this position. So thank you.
Mr. Chairman, I have a question. Sir, lady.
John, you're going to use their time.
I know. Well, isn't it true that Justice Thurgood Marshall ruled that retribution is not morally defensible as a basis for sentencing?
Mr. Chairman, I've never actually heard that, but I would agree with him, and I can imagine that he actually did say that, knowing him as I do. Thank you.
Senator Norman.
Mr. Chairman, there's a whole line of people out there, and I know we're really bright lawyers up here, but let's give them a chance to be heard.
Yes, sir.
Mr. Chairman and members of the committee, my name is Tom Antorcio, and I serve as Associate Director for the Virginia Catholic Conference. The conference supports this legislation because it helps to ensure that those who suffer from severe mental illness are treated humanely in the criminal justice system. We thank you for your time.
Thank you. Thanks for being here. Yes, ma'am.
Good morning, Senators. My name is Emily Ann Jankowski, and today I'm here to show my support for Senate Bill 1137. This bill raises important questions about Virginia's justice system. In Roper v. Simmons, the Supreme Court said, Capital punishment must be limited to those offenders who commit a narrow category of the most serious crimes and whose extreme culpability makes them the most deserving of execution. First are the severely mentally ill, the most deserving of execution. And second, since life in prison ensures that the public is safe and is less costly than the death penalty, should the goal of our system be retribution or justice? Senate Bill 1137 provides for justice. Thank you for your time.
Ms. Jankowski, we may retain your services as a consultant to the Crime Commission. Thanks for being here. Appreciate that. You did a very good job.
Good morning, Doug Ramsor. I'm with Capital Defender for Central Virginia, where I defend for the public defender system capital murder cases throughout. I've defended capital murder cases exclusively for 17 years now between Virginia and Georgia, and I would say not an insignificant number of my cases involve severe mental illness that is not really disputed for either side. And I can mean only to say that I think probably a quarter to a third of the people I've represented through that time have exhibited that in a way that I think is undeniable by either side, but we expend a tremendous amount of resources and money proving that throughout. And I think taking this, seeing that the problem, I think, would help us certainly fiscally lower the amount that we're spending even on these kinds of cases going forward, because the enormous amount of resources my office and the state prosecute for these types of cases. That's all I'm saying. Thank you.
Okay. Time is up. Step up, state your name and organization, and whether you support or oppose. That's it. I'm sorry.
John Mahoney, Virginia Association of Commonwealth Attorneys, and we oppose.
Thank you.
Thank you.
Well, actually, we'd be more than happy to hear opponents at some greater length. We gave 5 minutes for supporters. We'll give 5 minutes for opponents if you wish to be heard. Step up if you support the bill.
Mr. Chairman, Virginia Interfaith Center for Public Policy supports this bill.
Thank you very much. Yes, sir.
Yes, Mr. Chairman, the Mental Health America of Virginia and our 7 affiliates all support the bill.
Thank you. Yes, ma'am.
Mr. Chairman, members of the committee, I'm Jenny Halborn with the Disability Law Center of Virginia, and we support the bill.
Thank you. All right. Opponents.
Yeah, I'm John Mahoney. I'm with
And
Virginia
don't feel
Association.
compelled to use all 5 minutes.
Well, the attorneys. It's a difficult issue, very difficult, and really, it's a question of whether or not you want the death penalty. And we think this is just attacking the death penalty from the sides, and that all of these issues are addressed. The chairman talked about what we want as a society, then I heard one of the speakers talk about taking things out of the hands of the jury. Who better to represent society in a death penalty case than the jury? These are issues that, and I personally have never done a death penalty case, but I can tell you from all I've read, all I've watched, the mental health issues are tremendous in a death penalty case. In a prior life, I was a defense attorney. I went to the Capital Defense Workshop every year. Mental illness was a huge focus to get the death penalty taken off the table in those classes. So we would urge you not to pass this bill, and if you want to address the death penalty, address it that way fully. But we see this as making cases unendable, because the whole focus then is going to be mental health and what is a mental illness.
Thank you very much. Senator Norman.
Mr. Chairman, with all due respect to the citizens that appeared here this morning, I do think it would be appropriate to follow the course that we did last year, and I'd respectfully move that we refer the matter to the Crime Commission by way of a letter.
All right.
Mr. Chair.
Been a motion. I think it needs to be a motion to pass the bill by indefinitely with a letter to the Crime Commission requesting that it undertake consideration of this issue. Is that your motion?
Yes, sir.
Been moved and
Mr.
seconded.
Chair,
Senator Deeds.
I'll make a substitute motion, we report the bill.
Second.
All right. The substitute motion is to report the bill. Let's open the vote. to report?
Ayes 8, no 6.
Well, the bill is reported. I tell you what, Senator Deeds, with the understanding that it's not going to change the outcome, would you move to reconsider the vote so an amendment can be made?
Yeah, I'll make a motion.
And does this need to go to finance? All right, it's been moved and seconded to reconsider the vote by which this bill reported. All in favor signify by saying aye. Aye. All opposed. Bill is back before us. Mr. Benjamin.
Thank you, Mr. Chairman. On line 107, there's a reference to barring testimony if timely notice isn't given, but there's no guidance. The bill currently says under appropriate circumstances on line 107. And so to tighten that up a little bit, what I would suggest is that we replace under appropriate circumstances to the following: where the defendant is unable to show good cause for untimely notice.
Somebody want to make that motion?
I'll make that motion.
It's been moved and seconded. All in favor of adopting that amendment signify by saying aye. Aye. All opposed. The bill as amended is before us. Senator Deeds moves that the bill be reported. Senator Edwards seconds. All in favor signify by saying aye. Aye. All opposed. Adopt the same vote. All right. Are those all your bills?
No, Mr. Chairman, I have one more.
1375.
Yes, sir. And this is the hate crimes bill. You saw a version of this last year.
I think we saw the... Yes,
there is an
you're right.
amendment. I have an amendment in the nature of a substitute. What the amendment does is it merely removes the word disability. So my bill, once you adopt the amendment, would address gender, gender identity, and sexual orientation in the state hate crime statute.
All right, is there, and the amendment in the nature of a substitute removes disability?
That is correct.
All right. Is there a motion to adopt the substitute? Nobody?
Moved it.
Really?
I moved to adopt the substitute.
All right, is there a second? It's been moved and seconded that the substitute be adopted. All in favor signify by saying aye. Aye. All opposed, substitutes before us. Anybody have any questions of the patron? Everybody understand this bill?
Yes. I just want to give a two-second explanation.
Okay, go ahead.
I mean, what this does is it enables our prosecutors to have another tool in the toolbox if there's been an assault or an assault and battery or a more serious crime. If evidence demonstrates it was the result of a bias, and my bill again adds gender identity, sexual orientation, or gender, then there can be an increased penalty. It also provides for a civil penalty. And I just want you to know that hate crimes in our state have been going up. The state police do collect some data on hate crimes, but of course they're not collecting data on the categories that I just mentioned. And nationwide, crimes against those perceived with certain sexual orientation accounted for 20%. I think it's incredibly important that we send a message, both in policy and in substance, that says all Virginians are valued and all Virginians should feel safe in our Commonwealth. And in fact, we will take steps to ensure that. Right. That's the message in a nutshell.
Thank you, Senator Favola. And I would again note this is a bill that is largely the same as Senate Bill 112 from last year. That's on your sheet. Do you have witnesses? That's fine.
I have one. Excuse me.
Yes,
Morning,
sir.
Mr. Chairman. Mark Birnbaum, Office of the Attorney General. The Attorney General supports this legislation.
Okay, thank you very much. All right, the bill is before us.
Second.
All right, there's motion properly seconded that the bill be reported.
Ayes 6, noes 8.
Bill fails to report. Thank you very much, Senator
Thank you.
Favola. Senator Black.
Thank you, Mr. Chairman. I've got two bills,
And,
hopefully.
Senator McClellan, I'm really sorry you've been sitting here as long. We'll gladly call you. You are up next, but yes, sir.
Okay.
Senator Black.
Hopefully
you've
these
got,
will not
Senate Bill 1156.
take too long.
And
1156.
I would note that this is a bill similar to one that came from the House last year, correct?
I think, all that I know, we had one in the Senate a couple of years ago. This is a different spin on it, so I'm not too familiar with the House bill.
Okay.
What this bill does, Senate Bill 1156, first, it does not obligate localities to take any affirmative actions that assist federal immigration authorities. However, what it does do is it prohibits them from affirmatively acting to impede the enforcement of federal immigration laws or from enacting local ordinances or policies that restrict cooperation between local law enforcement and federal immigration authorities. This has become an issue in 5 states that have enacted laws limiting traditional police assistance to federal immigration authorities. Most prominently, former California Governor Jerry Brown signed a law designating California a sanctuary state and restricting what the way that police could cooperate with federal immigration authorities. I'd just like to point out, I've in quite a number of years as a federal law enforcement official in the military, that throughout law enforcement there is sort of a customary interaction on all levels, you know, local, federal. In Europe, we work with the Polizei in Germany. We work with the Bobbies in Great Britain, with just any number of organizations. And most of these cooperative agreements they sort of arise not out of statute or anything, but simply local comity between organizations that are concerned about similar things. And so this is really, I think, a somewhat new type of problem, this idea that we have governments coming in and saying that we prohibit you. We're not saying, you know, you have to do this, but we're saying we prohibit you from having these customary agreements. For example, I might be the local sheriff and the immigration authorities come and say, hey, look, you mind if we use an office in your facility? And we say, yeah, sure, you can, you know, hang your hat out there. These are just simple things. So what this does is simply to say that no locality will adopt ordinances, procedures, or policies that restrict the enforcement of federal immigration laws. And I would encourage you to adopt it.
Mr. Chairman, I have a question. I have a question.
Senator Edwards.
Is there any locality that has such an ordinance in Virginia? Are you aware of?
Well, there seems to be a dispute. Some say they have, some say they haven't. I don't think it really matters terribly much, because we're not telling anybody you will do it, but we're just saying you will not enact such rules.
All right. Senator Black, thank you very much. This is an issue that comes up annually.
Absolutely.
So I think that the members of the committee are very familiar with it and the policy arguments for and in opposition. But we're going to hear, first of all, anybody who wishes to speak in favor of the bill, step up. I don't know where your allies are, Senator Black, but there's a long line behind you. We'll give 5 minutes to those who wish to speak in opposition. You may want to confer amongst yourselves as to how best to use those 5 minutes because there is a long line. Go right ahead. Step up.
Good morning. My name is Wamika Avandere, and I'm with the Virginia Coalition for Immigrant Rights. And right now, I will list organizations who have signed on to oppose this bill, and that is CASA, Engage USA, NLIRH, Virginia Latina Advocacy Network, National Korean American Service and Education Consortium, Herden Reston Indivisible, Church World Service Virginia, Virginia Coalition of Latino Organizations, Progress Virginia, Virginia Interfaith Center for Public Policy, New Virginia Majority, and the Virginia Intercollegiate Immigrant Alliance.
Thank you. Thank you for being here representing those organizations. Appreciate it. Yes, ma'am.
Good morning, Mr. Chair, committee members. I am Vilma Seymour, and I'm with the Richmond Region League of United Latin American Citizens, known as LULAC, and we strongly oppose this bill. We feel this bill would create havoc for families and first responders by giving ICE agents free rein to continue inflicting psychological and other cruelties against immigrant communities throughout the Commonwealth without accountability. And I understand Senator Black's explanation that he's not coming in, he's not saying anything that's different. They're not coming in to stop. However, ICE agents are coming in posing as law enforcement, and that's where the dispute and the confusion come in. So whether or not however far that net is spread, it is not intended. The way that the federal laws are written, immigrant laws, that's not the way it's being implemented here in Virginia. Thank you.
Thank you. Appreciate your being here. Yes, ma'am.
How y'all doing? First of all, Leonina Arismendi. I am a reverend here in Virginia. My pronouns are they, them, so I would appreciate not being called a ma'am. Thank you. I just want to offer a very quick prayer. This is my first time here, concerned citizen, don't know exactly what's going on, but I just wanted to, because you mentioned earlier about the Presbyterian predestination, I felt like God was placing in my heart a little prayer today, and I just wanted to share that with y'all, if that's okay. Dear Lord, I just thank you because you are here, and I just thank you for every single person in this room speaking to power to the people that most need it right now. And I ask you, Lord, to please touch Senator Dick Black's heart. Please, Lord, ask him to drop this right now, because, Lord, we know that you have brought every single person into these shores, and we know that you have a plan for each and every one of them. And, Lord, I also know and I also trust that this bill, if it goes forward, is going to be a complete stumbling block onto your people, and that is not what I want. I want what your will is for us, and your will is for all of us to pursue a life of liberty and happiness. Thank you.
Thank you.
Good morning, Mr. Chair.
Good morning.
Members of the committee, my name is J.K. Davenport, Deputy Secretary of Public Safety and Homeland Security. The administration opposes this bill. Thank you.
Hey, good morning. My name is Diego Ragoso with the Immigration and Refugee Program at Church World Service. There are so many lawsuits against individual ICE agents, as well as individuals representing localities and regional jails, as well as sheriffs who have been sued because of complete infractions on the constitutional rights. There's actually a lawsuit happening right now in Culpeper County, and as well, this bill would undermine the collaboration that police officers have with community members in order to create a safer community. A lot of jails and a lot of sheriffs, a lot of police officers don't want to collaborate with ICE because they know it creates conflict issues in their community. So I ask that you oppose this bill.
Thank you for being here. Yes, ma'am.
Hi, good morning, everyone. My name is Ashna Khanna, and I'm the Legislative Director for the ACLU. I'll try to make it quick. On behalf of our 42,000 members across the Commonwealth, we really urge you to vote against this bill. There cannot be any sanctuary cities in Virginia. We're a national leader in enacting laws related to enforcement of immigration law. There cannot be any sanctuary cities. A combination of the Dillon Rule and existing state statutes make this existence.
I'm sorry. The time is up. The rest of the speakers may step up, identify yourselves, your organization, and state your opposition, but no speeches. I'm sorry. Come up. Yes, ma'am.
Hello, my name is Courtney Gardner. I'm with Alliance for Progressive Virginia, and we oppose this bill.
Thank you for being here.
Hello, my name is Seema Sked. As a Muslim American, I oppose this bill.
Thank you for being here.
Good morning, Lana Heath Day Martinez, representing CASA and also Church World Service, and both organizations oppose this bill and have written letters along with the Legal Aid Justice Center in opposition.
Thank you for your advocacy.
Jeff Caruso with the Virginia Catholic Conference. We oppose the bill because of various interpretations it could have. Thank you.
Thank you. Yes,
Good morning, Mr. Chair. Amanda Silcox with the Virginia Interfaith Center for Public Policy, and we oppose this bill.
Thank you. All right, the bill is before us. It's been moved. Is there a second? All right, it's been moved and seconded. The bill be reported.
Ayes 8, no 6.
8-6 vote, bill reports. Thank you very much. Senator
Thank
Black,
you.
you have another bill?
Yes, I've got Senate Bill 1157. Let me just say, this bill came to me from Charles Prophet. He's an individual who is a private process server for fee, and he informed me that there was a situation that arose at an HOA, which had some very small sign that said no loitering, no trespassing, that sort of thing. And anyway, the private process servers went into the HOA. They left service of process at the door and left. No incident or anything of that sort. But subsequently, the individual went to court, and he decided he would sort of get even, and so he swore out warrants for trespass against the process servers who had entered the HOA. And so he asked for some relief from this, and that's really the basis for the bill is, you know, if we're going to have, you know, we certainly have condoned and endorsed the idea of private process servers. And if they're going on, you know, on property to, you know, put the envelope in the door or whatever,
Senator Black,
then they shouldn't be subject to lawsuits.
Senator Black, I've got a number of issues that came up during discussion of this bill that may indicate that this isn't quite ready for prime time. You know, a couple of scenarios that could arise. Process server shows up, and it's one of those cases where you have to get personal service, not substitute service. He can sit on your front porch as long as he wants, even if you tell him to leave, waiting for the person he's trying to serve. Process server could enter a gated community and be immune from any liability. process server could come into your place of employment without authorization, being told to leave by people in that place of employment. I understand what you're trying to do, but maybe this goes a little bit too far. And private process servers, sheriff's deputies, they have some of the same challenges in serving process. I deal with civil process all the time. And you know, sometimes it's more difficult than others to get service. I'm not sure that this quite tackles the issue your constituent is seeking to tackle, or maybe it does in perhaps a more broad way than you intended. So
That's very possible, and I acknowledge that it is something that I think we may need to give a little bit of thought to.
Somebody want to make a motion to maybe give Senator Black and his constituent a year or two to consider this issue? All right. There's been a motion properly seconded to pass the bill by indefinitely. All in favor signify by saying aye.
Aye.
All opposed. Bill goes by.
Thank you very much.
Thank you, Senator Black. Next, Senator McClellan. Thank you for your patience.
Thank you, Mr. Chairman. I have Senate Bill 1108. This is a bill that will clarify that the Marsh Criminal Traffic Division at Manchester General District Court here in Richmond has concurrent jurisdiction with the John Marshall Criminal Traffic Division of Richmond General Court. There was legislation passed in 2017 that attempted to do that, but there has still been some confusion, and so this bill was recommended by the Committee on District Courts to eliminate any confusion on their concurrent jurisdiction.
You aware of any opposition to
I am
this
not.
bill? Anybody have any questions of the patron? The bill is before us. It's been moved and properly seconded to report the bill. I'm sorry, Steve? All right. Yeah, actually, thank you for slowing this down. Mr. Benjamin pointed out that we talked about striking line 91 from the bill. Is there a motion to that effect? You have any objection to that?
I don't believe so. No.
All right. Motion properly seconded to strike line 91. All in favor signify by saying aye. Aye. All opposed. All right, the bill is before us. It's been moved and seconded. The bill be reported. Record your vote.
Ayes 14, no zero.
All right.
Thank you.
Is that it?
That's it.
Oh, now I feel extra bad for making you wait. Senator Eben, and I think
there's a bill of mine that Senator Stanley has also, and I think we want to roll in. I don't know if you want to.
Senator Stanley, you want to step up?
Do you want to do that one first, Bill? This is to roll SB 1612 into 1013, and I can explain a small difference that I think committee would still probably.
Now, these are the driver's license bills that we dealt with last year, and we similarly advanced Senator Stanley's bill, which I think is the broader bill, in addition to the.
Same.
Oh, same, okay.
Mr. Chairman, I have a bill, Senate Bill 1080, which, no, not
Yes,
1080.
you do.
I have another, that's not the number.
1310. Do you want yours rolled in as well?
Yeah, roll it into Senator Stanley's bill.
All right.
Which is better, Bill? 13.
All right, we've got 4 driver's license bills. 1013, 1612, 1310, and 1613.
1613 is a different matter, a different take
All
on
right,
this.
well, let's deal with those 3 first.
Okay.
Senator Eben, you want to lead off or defer to Senator Stanley?
Yeah, I'll just briefly set the stage by saying that people who have their licenses suspended for failure to pay court fines and fees have a difficult dilemma. They have to either obey the suspension, lose the ability to go to the grocery store, pick up their kids from school or daycare, work, or drive anyway and face further punishment. These are the people who can't afford to take an Uber everywhere they need to go. And it also has a big impact on our criminal justice system. There was one study of an Ohio county that found it took 9 hours to arrest and prosecute those driving while suspended. 7 of those were spent on law enforcement. Further, it requires court hearings currently to suspend a person's license, which further clogs up court dockets. And the administration has replaced the funding for much of what would be lost in the governor's budget. So there shouldn't be a fiscal impact. Senator Stanley has informed me that he's got his bill has a small difference with mine in that he does have a reinstatement fee, which would cover any impact to the Crime Victims Compensation Fund. Is that the? Yeah, that's the only difference.
All right, Senator Stanley.
May it please, Mr. Chairman, members of the committee, this is the second time around. I put this bill forward last year. Of course, passed overwhelmingly in this committee, and it was 33, I think, to 6 in the Senate. Look, when it comes down to it, the difference being that the $145 reinstatement fee is split into 2 parts. $45 goes to the DMV, and I've worked with the DMV over the summer after my bill was killed in the House to work this out. And my understanding is they are in agreement with it. The $100 goes to the Victims Fund, which could see a significant amount of money which could compensate and take care of those victims in the Commonwealth of Virginia. And quite frankly, Senator Obenshain, Mr. Chairman, and others, what we have to have is also a process by which the DMV is going to be taking in a large number, if this passes and becomes law, a large number of drivers who have had their licenses suspended. And there are other, it is a property right, but it is still a privilege in the terms of qualification. So those kind of things have to be worked through. It just can't be an automatic thing. So there's going to be a cost to the DMV, and that cost is absorbed in a $145 reinstatement fee. But when we talk about cost, the things that bother me the most are when I sit in court and I see all of the time people who are at or below the poverty level get a traffic ticket, and their license is suspended if they miss one payment. They're not given notice. They're not brought back to court. It's just suspended. And they may or may not even know it.
Senator Stanley, I think you're on a roll.
Thank you.
But I suspect that your support could erode the longer we spend on this.
I'll take my chances. As I was saying, look, I guess what I'm just saying is about the cost. This is with 1.74 million days in jail for our Virginians. You're talking about $14 million a year. And with what it's doing in jamming up our court right now, we have judges right now who are trying to help people get their licenses, and it's jamming up our court system. We need to end this archaic process of putting people in jail and suspending their license because they can't pay a debt. We don't have debtor's prison anymore, Mr. Chairman.
Thank you very much. Anybody wish to step up and speak briefly in support of this bill with an emphasis on briefly? I'm going to start the timer, but I sure hope we don't use it all.
Mr. Chairman, Amy Willard with the Legal Aid Justice Center. You heard the bill last year. We still support it. The scope of this is huge. It's 1 in 6 drivers in the state of Virginia. Thank you.
Right. Thank you.
Mr. Chairman, members of the committee, my name is Jacob Fish. I'm with Americans for Prosperity Virginia. We're here with a broad-based coalition that also includes R Street Institute as well as also Prison Fellowship, and we all support the bill.
Thank you.
I am Kim Bobo, Director of the Virginia Interfaith Center for Public Policy. We strongly support this and appreciate Senator Stanley's work on this. Thank you.
Senator Eben and Senator Edwards, too, I'm sure.
Mr. Chair, members of the committee, J.K. Davenport, Deputy Secretary of Public Safety and Homeland Security. There are 627,000 people in Virginia whose license is suspended solely for not paying fines and costs, puts them in a vicious cycle of debt. We ask that you support this bill.
Thank you. Anybody wish to speak in opposition to this bill? All right, bill is before us. Senator Edwards moves that and does this need to go to finance? Yeah, first of all, is there a motion to roll into Senate Bill 1013, Senate Bills 1612 and 1310. It's been moved and seconded. All in favor signify by saying aye. Aye. All opposed. Those bills are rolled together. Senator Stanley, I assume, moves to report and re-refer to the Committee on Finance. Is there a second?
Second.
It's been moved and seconded. Record your votes.
Oh, that's right. All right, there you go.
Sure. Abstain, I guess. Heads. All right. Picking up votes. All right, Senator Eben.
Okay, so now we have Senate Bill 1613, Mr. Chairman. This deals with driver's license suspension for non-driving offenses and most notably drug offenses. The committee had passed, I don't know if it was unanimously or just overwhelmingly, a similar bill on marijuana-related offenses a few years ago. We know that there's 200,000 people in Virginia who have their licenses suspended for non-driving offenses, and as I stated before, they face the same difficult dilemma after they've faced any incarceration or any other discipline or whatever the court imposes on them to drive and how they're going to get to work, et cetera. We know that Virginians, about 38,000 lose their licenses every year, according to the Prison Policy Initiative, and that 99% of license suspensions for drugs in Virginia did not even involve a motor vehicle. 42% of New Jersey drivers who had their licenses suspended in similar circumstances lost their job. This all came about under, I think it was several administrations ago, Senator Lautenberg of New Jersey put a Get Tough on Crime bill in at the federal level. It said that every state had to suspend the license or risk their highway funding money. Now it's states can just put in a bill like this, which serves as a resolution for the governor to ask to notify the Federal Transportation Authority. And this bill has an enactment clause that just does just that. We know that only 12 states still suspend the licenses on drug offenses, and that includes all the states that border Virginia do not suspend, West Virginia, Kentucky, Tennessee, North Carolina, and Maryland.
Adam, I think you're in good shape.
Okay, so I don't want to talk too long.
Anybody, no amendments necessary,
Well, I
this,
should,
correct?
just, Mr.
Okay.
Chairman, just to be clear to the committee, this also includes things like when you, non-driving related offenses like trespassing, shoplifting, that's right.
Yeah, this is the same as last year.
Learn from me, Adam.
Anybody wish to speak briefly in support of this bill?
Mr. Chairman, members of the committee, J.K. Davenport, Deputy Secretary of Public Safety and Homeland Security. The administration supports this bill. This bill aims to target those who are suspended for non-driving related offenses who are a danger to the road. We ask that to support this bill. Thank you.
Thank you very much. Supreme Court has some thoughts.
Good morning, Doreen Dalton from OES at the Supreme Court. We have an implementation concern on line 73. The phrase, it relates to suspensions for non-payment of fines and costs, and it says not pertaining to the operation or operator of a motor vehicle. It would be our request that this committee define those, what statutes that would apply to or not apply to, as suspensions for non-payment of fines and costs require us to program them into our system, and then it is an automated system that notifies the DMV upon the non-payment event occurring.
I suspect that'd be a pretty long list, wouldn't it, Kristen? Do you have a list you'd like us to include?
No, sir, we see that as a legislative function.
Okay, it may wind up being a judicial function. All right, well, the bill is before us. It would need to go to finance if it is the will of the committee to report it. Is there a motion? So moved. Report and re-refer, properly seconded. Vote is open. Yeah.
Okay, I thank members of the committee.
You're doing pretty well today. All right. Let's strike the board. All right. The motion is to report and re-refer to finance. Sorry, you lost second time around, Adam.
Ayes 13, no zero, abstentions 1.
All right. Next, we have committee members' bills. We have Senator Howell, 1076, which I think is a familiar bill. This is a bill that passed out of this committee 11-4 last year. I'm sorry, 1076. I'm sorry, it was PBI'd last year. That's right, sorry. All right, Senator Howell.
Thank you, Mr. Chairman. Yes, you've seen this bill before. It was the recommendation of the Crime Commission two years ago on a 10-2 vote in the Crime Commission. And I find this one of the more fascinating bills I've ever done because it is a direct clash between really good intentions. And so where you fall on this varies, you know. I fall on trying to protect domestic violence victims, and most states now do that. In fact, only 2 other states have the same approach that we have in Virginia. But civil libertarians are, frankly and rightly, also very concerned about this bill. I'm hoping my lifeline is behind me.
He sure is. So what this bill, for those not familiar with rules of evidence, typically prior inconsistent statements are only admissible to go to the credibility of a witness. This would allow, in limited circumstances, prior inconsistent statements to be admissible for the truth of the matter asserted. The intention, I think, is for situations, primarily domestic violence situations, where somebody may have been intimidated into changing their story and recanting allegations of domestic violence, that the prior statement would be admissible for purposes of proving the elements of the underlying offense. Mr. Doucette, you want to step up and speak in favor of the bill?
Mr. Chairman, Mike Doucette, Executive Director of the Virginia Association of Commonwealth's Attorneys. This issue was vetted by the Crime Commission back in 2017, and as a result, the Crime Commission found that in 47 states and the federal courts that there's some allowance that is made for prior inconsistent statements for the truth. There are 3 states, Virginia, North Carolina, and New York, where that is not the case. Last year's bill was similar, but it was broader. This is not the same bill that was introduced last year. Last year's bill was the federal rule of evidence, basically, but there was some additional stuff that got people very worked up. It dealt with recorded statements. This is modeled on the federal rule. And so in order for the prior statement to be introduced in this particular matter, it would have to be a statement that was given under the penalty of perjury. Again, last year the bill was one where if the case, the statement had been recorded in some audio or visual fashion, that it would be admissible. That has been stricken, and this is just the federal rule, which has been adopted by, obviously, the federal courts, as well as 26 states. Yeah. Anyone who has handled domestic violence or sexual violence cases will tell you that victims often recant the true prior statements for reasons of intimidation or for reasons of economic dependency or for any number of other reasons. What this bill would do, and as has been pointed out by the chair, is in Virginia, these statements are only admissible now in Virginia to impeach the declarant's prior statement. They're not offered for the truth of the matter. And so what happens is when a victim recants in court, the court is left with no other option. Even if there's all sorts of corroborating evidence, the victim is left with no, or excuse me, the court is left with no other option but to dismiss because the victim has recanted in court. This would allow, in these limited statements where the previous statement had been made under the penalty of perjury, would allow the trier of fact to consider both statements. Now, it does not mean that the court is going to consider and only hold with the prior statement. The Commonwealth is still going to have the burden of proving beyond a reasonable doubt that the crime did in fact exist. But it does allow the court at least to consider that statement in addition to whatever other corroborating evidence there might be in order to determine whether or not the Commonwealth has proven its case beyond a reasonable doubt. So,
Mr. Chair.
Said all that without taking a breath. That was really impressive.
You saw I was going to ask a question.
Mr. Chair.
Senator Peterson.
You just told us that it's only statements made under oath. But if I read subparagraph 2 here, it says, as the statement is proved to have been written or signed by the witness, 2, the witness acknowledges under oath the making of the statement in his testimony at the hearing, or 3, the statement is proved to have been accurately recorded by virtue of an auto recorder, auto recording, a video recording, or any other similar electronic means.
Mr. Chairman, Senator Peterson, I am sorry. That was not the bill I had asked the senator to introduce.
Okay, I'm looking at Senate Bill 1076. This is basically, I could take a,
That is last year's bill. That is,
okay, I could write something with a Crayola crayon.
So we have a substitute?
We will.
Okay, good.
I'm
That's a
sorry.
very major difference,
There's
sir.
no question about it, Senator.
Okay.
And that is not the bill I asked to be introduced.
All right, well, that's not the bill we
I think
got.
what happened
Sarah
was-
Howell, you want this to go by,
Yes,
and
thank you, and we'll make a substitute.
I think we probably have an idea as to where it's headed. I love your bill, but others may not. So
I don't
anyway,
like it under any
thank you very much. Without objection, this will go by.
And also, if 1395 could go by for the week, that's.
Without objection, that one's going by as well. We discussed that. Senator Vogel, Senate Bill 1466.
Good morning, Mr. Chair, and members of the committee.
Good morning.
I have Senate Bill 1466, and this bill is not entirely new to this committee.
No, it's not. Which means we've acted on it
And you
multiple
may
times
act
in the
on
past.
it, you may act on it similarly this morning, but I bring it to you because every year that I've been in the Senate and in the years when Senator Potts preceded me, Sheriff Lenny Milholland was a tireless advocate for doing something, both as a deterrence factor, something to educate the public, and then something actually in the code that would have an impact on people who intentionally leave their children unattended in cars. And in the years since I've been in the legislature, there's been a lot more engagement, both in the media and in the public and among advocacy organizations, attempting to educate people about the risk to children of being left in a vehicle. And the numbers every year are really sobering when you consider the numbers of children that die as a result of heat stroke left in a car. And since 1998, it's been more than 800 deaths. And they break down, interestingly, about, I think 27% of those roughly are because children find their way, or no, I'm sorry, 27% I think are an accident where the parents leave the child in the car, they forget, and the child dies. Another percent, somewhere around the 20s, is roughly because children find their way into the car and lock themselves in and can't get out. But the rest are intentional. Parents go to a store and leave a 2-year-old in a car seat on an 85-degree day, and the child dies from a heat stroke. And the temperature, it only takes a couple minutes, maybe 15 minutes or so, for it to get to be 150 degrees in a car when it's 86 degrees outside.
Mr. Chair. Thank you. Jill, a couple of things. I mean, one, I don't think anybody on this committee would dispute or argue with your intentions and motivations and Sheriff Mulholland's. Second, parents can already be prosecuted for reckless endangerment and a variety of other offenses. If a child dies, potentially for manslaughter or something else. When we went over this bill, we had to stop talking about it because we came up with so many different scenarios in which somebody could be charged under this bill for something that shouldn't be criminalized. Kristen, you have any any hypothetical
Go ahead, Kristen.
scenarios that you can think of that might fall into that category?
Yes, Mr. Chairman, one that came up in committee was when the mother closed the driver's seat door, and in between then and getting to the passenger side door, the child had locked herself in the car. And the mother went into the house to try to find the keys, at that point leaving the child out of the sight of vision for a few minutes. So that was one example that we could come up with.
And under that scenario, under this bill, mom would be committing that crime?
Class 1 misdemeanor, yes.
Okay.
Yes, sir.
So the bill is before us. Do you have anybody you wish to have speak in favor of the bill?
No, I didn't have the sheriff
Or
come
in
down this morning.
opposition? All right, and those concerns have nothing to do with your motivations.
Fine, I understand.
Anybody have any questions of the patron? Any motion on the bill? Sorry? There's been a motion to pass the bill by indefinitely, very gently. Is there a second to that motion?
Second.
It's been moved and seconded. Vote is open to pass the bill by indefinitely.
Thank you, Mr. Chair and members of the committee. I appreciate it.
Thank you.
Ayes 11, noes 3.
All right, Senator Edwards has left the room. While he's gone, we'll just kill his recodification bill. Kristen, is that okay?
As long as there are no questions, Mr. Chairman, that's fine with me.
All right, while we wait for Senator Edwards to come back, we'll take Senator Reeves, and then we've got a number of eminent domain bills and a couple of witnesses who are here. We're going to take the eminent domain bills up. Okay, Senator Reeves.
Thank you, Mr. Chairman. Before you, Senate Bill 1251, and before anybody gets into hysteria, we're not trying to legalize switchblade knives, which this committee passed out once before, and I think I gave a pretty good example of why the actual switchblade law is kind of archaic with the technology that's out today with speed safe and assisted opening knives and everything else. But this is a little bit different. This is a bill that would allow a manufacturer of such devices to actually set up shop here in Virginia. So this is a jobs bill, and many of you are probably not aware, but there's a company called Blue Ridge Knives, and they're located in Marion, Virginia, and they're one of the largest knife distributors in the world. But they can't actually handle, quote, switchblade knives because it's in our statute. So what this bill does, if you look at it, it adds a subsection B and just basically says that subsection doesn't apply to the manufacturer, distributor, or retailer of switchblade knives. I have Todd Rathner here from Essential Tools to speak on the bill and why they think it's important that we allow manufacturing of them even though we can't sell them here.
All right, thank you very much. Step right up. Yes, sir. Welcome.
Thank you, Mr. Chairman, members of the committee. My name is Todd Rathner. I represent Knife Rights. We're a national organization of knife owners, manufacturers, and collectors, and folks that hand make knives. Senator Reeves is correct that Blue Ridge Knives out of Marion is the largest knife distributor in the United States. The only type of knife that they can't ship from Virginia is so-called switchblade knives, what the industry calls automatic knives. There's another distributor, Blade HQ, that's also located in Marion. They actually have set up warehouses in Utah so that they can ship these knives out of Utah, which brings the jobs to Utah and any tax revenues that may come from this. Utah is getting the benefit instead of Virginia. In 2012, Washington State passed a very similar bill to this that said they could produce them in the state, but people couldn't possess them. There have been no negative impacts from that in Washington State. And in Tennessee, another manufacturer or distributor did the same thing. We were able to pass a bill that was very similar. They realized over $1 million in sales in the very first year. And with that, and 44 states allow possession. With that, I know there's a lot of work for the committee to do, so I will just stand for questions.
Thank you very much.
Thank you.
All right. Anybody else will speak in favor of the bill? In opposition to the bill?
Good morning, Mr. Chairman. Andrew
morning.
Goddard, Virginia Center for Public Safety. We oppose any deregulation or decriminalization of bladed weapons. And we believe that this bill is a incremental attempt to get that to happen here in Virginia. Once those things get into the hands of distributors and retailers, it's impossible to know whether they will actually end up being sold to Virginians here in the Commonwealth. So we oppose the bill. Thank you.
All right, thank you very much, Mr. Goddard. Any other witnesses? The bill is before us. Senator Reeves moves, properly seconded, to report the bill. Vote is open.
Stand. There we go.
All right.
Ayes 9, noes 4.
All right, the bill reports. Do you want to take yours up, Ryan? All right, 1379. 1379.
Mr. Chairman, this came to my attention. I think a number of individuals, including prosecutors, law enforcement, and the Attorney General's office, who are charged with addressing child pornography cases, have come to a situation where when a number of images are found in a particular case, that case will often move forward with only 2 or 3 indictments or charges. And as a result, the remaining images that could have been found on the technology possessed by the defendant would not go into the registry that is used to identify victims. So this would allow those other images that are not in those 2 or 3 charges that move forward to go into that registry so more victims could be identified and assisted. Mr. Chairman, I do believe there came a question at some point about if somebody could opt out. That's not in the current statute, but at all, and for the most part, we don't know who the victims are. That's why we're putting their images into the registry to try to
But the
identify them.
opt-out, though, deals with victims who you do have identified. Would that do any harm to the bill?
Mr. Chairman, I don't think under the current statute that is in place,
Okay.
that there's an opt-out provision there, but because it's not been contemplated, for the 99.9%, I might get some tag in from assistants, the
You got
victims
it.
are
It's right behind you.
not known. So that it's not like there's, in rare circumstances they are, but for the most part, they're not known.
All right, any questions of Senator McDougall? All right.
Camille says I'm close.
Come on, step right up.
Good morning, Mr. Chairman. My name is Camille Cooper, Director of Government Affairs for the National Association to Protect Children. So this statute was established in 2006, and it was established before anyone had an idea of where the field in terms of technology was going to go. It's 2019 now, and technology has really advanced. So the goal of the registry has moved towards a more victim-centered approach of being able to identify those little children that are in those images, that are languishing, that have not been rescued yet. In order to be able to do that, you have to have the known images in the registry to be able to compare the unknown images against, to be able to say, this is an unknown victim, this is a known victim, we already know who this is. So in order to be able to do that, you got to have all the images. And then the software itself can say, this is a known image. You don't have to look at this again. We know who it is. You don't have to identify the victim. Just keep it here, make a hash of it, keep it in the library. And then there's this image here. We don't know who this is. We've never seen this image before. This is a child who potentially has not been identified, has not been rescued, and still may be in harm's way. So we need to have both sets of images in order to compare them against each other in that
Gotcha.
registry to make it robust.
Understand.
It's,
All right.
it's a restricted law enforcement database. It's in state police control. It doesn't, nobody else has access to it.
Right. Anybody have any questions of the patron? All right, the bill is before us. It's been moved and seconded the bill be reported.
Can I vote my proxy from here? And me.
Yeah. All right.
That's 1400.
Mr. Chairman, I also have
1383.
another simple bill. Mr. Chairman, this came from the Committee on District Courts and the Supreme Court. So if there are any questions, I'm happy to pass them off to the Supreme Court. And this would provide some additional guidance if people have certain infractions and they're complied with, for those fractions to be dismissed in payment of cost.
And the only question I heard was whether this isn't already done.
Mr. Chairman, I think that this is, from my conversations with the Supreme Court, their experience is this is the standard practice, but maybe not the uniform practice. And so this codifies the standard practice.
All right.
I
Anybody?
don't think this is the most earth-shattering thing we've taken up today.
It's Senator Peak.
Yes, Mr. Chairman, Senator McDougal, do you still have to pay court costs?
Mr. Chairman, yes, in the last provision of the legislation, it would say, well, I would say under this provision, even if it's dismissed, that you do still pay court costs.
And Mr. Chairman?
Senator Peak.
And I just have the summary in front of me right now. I can't remember. If you had if your car was registered and you just hadn't put it on, so this says on, if you comply on or after, if you were registered, just hadn't put it on the tag, does it address that at all?
Mr.
Some
Chairman,
of us do that by accident.
Mr. Chairman, I don't think it's that specific. I think a court can dismiss a case for there not being enough evidence, and then a court could dismiss a case for compliance with law. And this is contemplating that compliance with law. Traditionally, if it's complied with law, the clerk's office still has to take in that summons, the sheriff's department or state police have to write it, enter it into the system. It has to come up on a docket, and they have to redo it. So that's the reason for that. But if they're not guilty, then they would not have to pay the cost.
All right. Any other questions? Bill is before us. Senator McDougal moves the bill will be reported. Is there a second?
That's 1400.
All right.
Thank you, Mr. Chairman, for
bill reports. Now
taking
let's
me
take up the eminent domain bills now. Senator Peak, you've got 1039.
Good morning, Mr. Chairman, members of the committee. 1039. This has to do with commissioners. I tell you, our office does some work for the, Attorney General in these condemnation cases. So
this is a big government bill?
It is it's a fairness bill is what this is, because I always and ultimately believe in fairness and transparency. And what happens with these commissioners, we happen to be handling one of these. The person whose property was in dispute, they picked their commissioners. My partner comes up to me. The other side submitted this list of commissioners. Do you know any of them? I said, yes, he plays golf with all of them every Saturday. And that's what it turns out. And then my legislative aide. Yes, a lawyer handles these cases on the other side, finds the commissioners, takes them out to dinner, takes them to shows, does these things. That's my concern with the commissioner system, is there is no impartiality, so thus this bill.
So that's been your experience or your partner's experience?
My partner's experience. I do not handle these cases.
All
so
right.
it's my law partner's experience. As I saw it in that, and I've heard it from several others. I understand there's a tad bit of opposition.
Well, let's hear from those who support your bill first.
I thought this might happen.
Let's hear from those who have a modicum of concern about your bill.
Good morning,
They don't have to talk that long if they don't want to, Mr. Chairman.
Mr. Chair, members of the committee. My name is Josh Baker. I'm an attorney at Waldo and Lyle. I may have just been referenced in some of the remarks here, but the commissioner system, just for history's sake, was the exclusive way that eminent domain cases were tried in this Commonwealth for hundreds, if not dozens of decades. We then changed to, excuse me, in about 2001, it went to exclusively jury system. In about 2006, 2007, this body saw fit to restore the commissioner system. And now, presently, an owner whose property is being taken has the option of choosing a commissioner system or a jury system or a bench to the court. And so for reasons of fairness, for reasons of transparency, and I welcome the senator's approach to this and be happy to work with him to reform the commissioner system, but to remove it would be the absolute wrong thing to do. So I would oppose this measure.
All right. Thank you. Anybody else wish to speak in opposition?
Mr. Chairman, members of the committee, my name is Stephen Clark. I'm an attorney with Waldo & Lyle, and I represent private property owners in eminent domain cases, and I agree with Mr. Baker's remarks. My clients have asked me to oppose this bill because it eliminates this option for property owners. We think as a matter of fairness, property owners should be afforded the ability to choose whether they want to have commissioners or a jury or a bench trial, given the circumstances of their case. And so we think this decreases the fairness level for property owners. Thank you.
Mr. Chair. Oh, sorry.
Good morning, Mr. Chairman, members of the committee. I'm Steve Rossi with the Family Foundation of Virginia, and we respectfully oppose the bill. About, was it to 2007, I believe it was, commissioners were omitted, and we had a big bipartisan effort to reinstate commissioners in addition to juries or the bench, just to give the property owner more options as to which might, help the property owners give the best possible fair, opportunity for fairness in the trial. So,
and
for that
commissioners are used, and maybe Mr. Clark wants to step back up. Commissioners are used in cases where there may be complexity. They're kind of a blue ribbon juror in cases where perhaps people drawn from the general jury list may not have the expertise to address some of the property valuation issues. Is that right?
That's correct, Mr. Chairman. And they are still subject to voir dire. They're subject to disqualification if they're not impartial or if they're
so if
too connected to either party.
A commissioner played golf over the weekend with a lawyer, and that was brought to the attention of the judge. Judge would have the discretion to strike that commissioner?
Yes, absolutely, Mr. Chairman.
Okay.
Thank you.
Just checking.
Mr. Chairman, members of the committee, Nicole Riley with NFIV, and we've long followed the eminent domain legislation and certainly do not like the idea of eliminating an option for a property owner. Certainly if there are instances and maybe if there needs to be a look at any kind of reform of the process, we'd certainly be happy to be a part of that conversation, but certainly don't want to eliminate options for property owners. Thank you.
Sir Peak?
Yes, I certainly understand that, and I'm talking with some of the people who just spoke. I think that it certainly, I did not want to eliminate the commissioner system, which this bill as drafted, I understand does. So I think it'd be appropriate to continue this bill so we can address the commissioner.
You want to pass it by indefinitely so that we can maybe
get these
look at
parties
this?
together and look, because I'm only interested in fairness for everyone.
All right, it's
involved.
been moved and seconded that we pass the bill
And
by
transparency.
indefinitely.
Ayes 14, no zero.
All right, next, Senator Peterson, we've got 1403.
Yes, sir. Good morning, Mr. Chair, members of the committee. Senate Bill 1403 has to do with when costs are allowable if you are successful in an eminent domain case. As you know, in eminent domain cases, by and large, a private property owner is represented by a private attorney. There is no fee shifting in eminent domain, but we do have a statute on the books which says that if you recover more than 25% of what was offered, then you are allowed to recover your costs. Those are reasonable costs other than attorney's fees. So it's not attorney's fees, but if you had to pay for an expert, whether it was an engineer, a real estate appraiser, or someone of that ilk, that you could recover that. Now, that's the law that we have right now, but at the time we passed that law, for whatever reason, we carved out public service companies. So if a public service company comes along and condemns your land and you fight them in court and they lowball you and you go to court and you get a recovery above 25%, not only do you have to pay your counsel, but you also have to pay all your experts, which will obviously come out of your reward. So I'm not quite sure why we made that discriminatory treatment, but I have a bill in to end that disparate treatment.
I
And that's
think
what it
when
does.
that bill passed, the prediction was that somebody like you would be back with this bill. So I
Yes, sir.
remember pretty clearly.
Yes, sir.
All right.
Here I am.
You have people who wish to speak in favor of your bill?
I'm sure I have at least one.
I think one is
There he
standing up
is.
behind you.
All right.
Mr. Chairman, members of the committee, yeah, we greatly support this, this bill. This would put all condemning authorities on the same footing. And more importantly, it puts an owner on the same footing, no matter who it is that is taking their property for a public use. No dispute, we need these projects, they need to go forward. But this would close a disparate treatment of our public service utilities so that when they also condemn property from owners, that they play by the same rules as everybody else, and that when an owner is successful against them as they might be against someone else, that that owner is made whole by the reimbursement of those costs. So we urge you to vote in favor of this.
Thank you, Mr. Baker. Next.
Mr. Chairman, members of the committee, Steve Rossi, Family Foundation. We support this bill as well. It's just another element to fairness in the eminent domain process. Thank you.
Thank you, Steve.
Mr. Chairman, members of the committee, Nicole Riley with NFIB, and we also support the legislation. Thank you.
Thank you.
Hello, Katie Hellebush representing the Virginia Forestry Association, and we also support this. Thank you very much.
Thank you. Are there those who would have a contrary view and wish to speak in opposition to the bill?
Mr. Chairman, members of the committee, I'm John Rust on behalf of Dominion. If you all recall, many of you do, back in 2005, we had a major rewrite of the condemnation legislation. And as a part of that, in order to encourage good faith offers, we made a provision that if you recovered more than 30% of the final offer you made, when you'd received an appraisal from the landowner, you were responsible for certain costs, and that applied to everybody. And that was adopted in 2005, and it continued until 2016. In 2016, we had a bill that would basically have changed that to a 20% rule based on the initial offer. We had a long discussion about that bill. It went into conference, and ultimately the election was to exempt the public service companies from the new rule and allow them to continue to work under the old rule. A lot of the reason for that is that the public service companies are condemning linear rights-of-way. They are not necessarily condemning fee in every instance. And it is something where we had an exemption for small amounts, $10,000 or less in the easement as a part of the original statute. That doesn't appear in the new statute. And it was felt that there was a reason to accept the public service companies from the new rule. That compromise has only been in effect for 3 years. We'd appreciate it if you would abide by the compromise we reached in 2016.
Right.
Mr. Chairman, I have a question.
Senator Edwards.
The current law, regardless of who it applies to, whether public service corporation or not, simply says the court may order. It's not required. It's discretionary, correct?
In both instances, it's may order. It varies in terms of what the criteria are, whether it's a public service corporation or whether it's a normal condemnation. Senator Edwards, Mr. Chairman, if you're looking at 245.1, that was the additional statute that was added in 2016. The main statute, which is the one which has been in effect since 2005, is 245, which is not a part of the bill that's in front of you right now. It's being repealed by that bill, but it's not actually there, the language.
I'm looking at Senate Bill
Senator Edwards.
1403.
Mr. Chairman, yes, the 1403 has Senate Bill, or has 25.1, 245.1, but it is in effect amending 245, which is being repealed by this section. 245 is where the language appears.
But again, Mr. Chairman, it does say may, it's discretionary on the part of the court, right?
Yes, sir. Yes, sir.
Okay. And secondly,
Senator Edwards.
Mr. Chairman, it does not include attorney's fees. The landowner cannot collect attorney's fees at all.
Mr. Chairman, I would agree with that.
Okay, and number two, in addition, Mr. Chairman, the only thing that the landowner can recover is reasonable costs and reasonable expert fees, up to 3 experts or as many experts as the condemning authority calls to testify, right?
Mr. Chairman, I would agree that is the language of the statute.
Okay, all right. Why is that unreasonable?
Mr. Chairman, I would say that's not unreasonable, but the criterion upon which this statute applies is different for public service corporations than for other condemnees. And basically, the language for public service corporations deals with a 30% difference, not a 25% difference, and deals with an exception for easements that have a value of less than $10,000. Those are exceptions we felt were very important. It also requires, as a condition of that final offer, that there be an appraisal which the landowner provides. This is not required under 245.1. That language is not going to appear in the bill before you, Senator Edwards. You need to look at 245 to see that language.
Mr. Chairman, do you have a proposed amendment?
My proposed amendment would be to leave 245 like it is.
Okay.
All right.
One other item, Mr. Chairman, if this bill is to go forward on all condemnation matters that we've dealt with in the past, we have exempted condemnations that are now pending. It would only apply prospectively. That language does not appear in this bill.
All right.
Thank you, sir.
Thank you. Yes, ma'am.
Katrina Jones Robleski, Columbia Gas of Virginia. We also oppose the bill.
All right, thank you. All right,
Mr. Chairman,
Senator McDougal.
can I ask a question of Mr. Ruff? Is the biggest concern for you the under 10,000 as opposed to the 25 versus 30%? Is that where the majority of your condemnations are for properties, for condemnation of property less than $10,000?
Mr. Chairman, I'd say to Senator McDougal, yes, that is the major concern. There's also an issue that the 245.1 shifts it from the final offer based on an appraisal to the initial offer, which is a major shift in burden.
Mr. Chairman.
Sir McDougal.
Maybe this question is for Delegate Peterson, Senator Peterson.
Go, Councilman,
Senator,
I don't care. Yeah.
So, do you, if you were looking at that other section and that got lowered from 30 to 25, would that achieve your goal?
Well, I'm not a huge fan. First of all, I don't like the fact that we treat public service corporations different than we treat VDOT. Let's just start with that, okay? But secondly, when you make it, the initial offer is the one you're required to make before you take the property. When you leave it to the last offer, someone's already had to hire an attorney, they've already had to litigate, take depositions, hire their own experts, and then suddenly they drop a final offer on you that, may be a little bit closer to the reality. So I like this statute better, and this is the standard we hold VDOT to now. Now, I understand what Mr. Rust is saying, that you got these smaller takes under 10 grand, and look, I'd like my bill as it is right now. If you wanted to carve out that exception, at least for public service corporations, I'll take that over nothing. But this is a real issue, needless to say, in certain parts of the state.
Any other questions? All right, the bill is before us. Senator Peterson moves that the bill report.
Yes, sir.
Second. Properly seconded. Any further discussion? The roll is open.
Oh, I got it here.
Ayes 11, no 0, abstentions 2.
All right, bill reports. Next, 1404.
Thank you, Mr. Chair. 1404 deals with a somewhat narrow class of eminent domain cases, which frankly are cases which are not challenged. And before we go further, I need to make a amendment, which I worked out with VDOT, which is to strike the language on lines 17 and 18, which says including the release of any liens attaching to the funds. So if that could be stricken. And
Senator Peterson moves, Senator Deed seconds that amendment.
And that's
All in-
also in line 77 and 78, so that's just duplicative.
Kristen, you have that? All right.
Okay.
All in favor of adopting that amendment, signify by saying aye. All opposed, that amendment's adopted.
All right, Mr. Chair, members of the committee, this deals with that situation where a action is filed to take the property, the money is paid to the clerk. So let's say they're going to condemn and they pay the $50,000 or whatever amount that they found as the fair market value. It's sitting with the clerk. The parties then work out an agreement, and then the landowner who has to draw down the fund has to file a petition to draw down the fund. So they actually have to pay the filing fee, which is $200 or $225 or whatever it is, because you can't do it by an agreed order. You actually have to initiate an action, and so they would file the petition. So in this case, this just clarifies that the costs of filing the petition, which are defined as the actual filing fee or the service fee, would be taxable to the condemning authority. So in other words, the landowner doesn't have to come out of pocket to file that petition to draw down. Now, there's also a point which Mr. Rust spotted, and he's 100% correct, that there's also language that talks about the interest on funds payable. So if money is paid into the clerk, and this has been a question I've had with clients, is interest earned on that? Well, we passed a law a couple years ago saying you get the judgment rate under that money under 8.01-382. The code is a little bit more complicated. They use an IRS statute, but this would just say that the money paid on account to the clerk would accrue interest at the same rate under 8.01-382. So this is really two parts to the legislation. I think the interest issue might be a little bit more controversial. I don't think the drawdown really is all that controversial, but I'll let Mr. Rust probably knows that better than I do.
All right, let's hear from anybody who wishes to speak in favor.
Mr. Chairman, members of the committee, again, Josh Baker, we're in favor of this bill. It does assist landowners who have had their property taken by then not suffering that final insult of having to go pay to get their own money out of court. And so that would be a great change to the code. We appreciate your consideration and support.
All right, thank you. Next.
Steve Rossi, Family Foundation, and for the reasons Mr. Baker just stated, we support the bill.
Great, thanks.
Mr. Chairman, Nicole Riley with NFIB, and we also support the legislation.
Thank you.
Mr. Chairman, Katie Hellebusch with the Virginia Forestry Association, and we also support this. Thank you very much.
In opposition, I'm sorry.
Can I ask?
Sarah McDougal.
Senator Peterson, the interest port, do we require our circuit court clerks to collect interest on anything else?
You know, I can't think of any other situation where money's intentionally paid to them, at least by statute. I mean, I've had cases where I paid money into the court, but this would be a little bit unique. So as of right now, we have the IRS code, and I'm not quite sure what that dictates, but the short answer is not that I'm aware of.
Mr. Chairman, after we hear from other, I wouldn't mind hearing from the circuit court clerks, because it seems like an administrative challenge for them. I'd like to hear their perspective.
Senator Norman.
Chap, before you
Yes, sir.
leave, I may be wrong, but to collect interest on an interpleaded situation, don't you have to specifically request the clerk to do that?
You know, Senator, I'm not sure. I've never done that. I just put it in.
All right, in opposition.
Mr. Chairman, John Russ for Dominion. Got a couple issues, if you don't mind. I think on the first issue on collecting costs for filing the petition, we don't have a problem as long as costs means the court cost doesn't mean attorney's fees. One of the things we have done in the past is generally excluded attorney's fees from that recovery of costs. I know the general interpretation of costs is it does include attorney's fees, but I'd like that specifically in the bill if you could to protect us from charges on
But Jack, I mean, to do that, I mean, shouldn't we go back through the entire code and do that? I mean,
we do it in
I don't think
condemnation.
that there's a lot of dispute as to what costs mean, is there?
I agree with you, Mr. Chairman, but you'll find in other statutes which deal with costs and condemnations, we have included or excluded attorney's fees expressly in the statute. That's the only issue I'm raising on that. The interest issue is a little bit more complicated. I ask you all to look at subsection G for a second. Senator Peterson and I don't read this the same way. As I read this statute, the interest that they're referring to is interest that's payable on the amount to be deposited before it's deposited into court. In other words, this interest applies only to funds until they are paid into court. I know that there apparently is some difference among the circuit court clerks in how they handle it. In Fairfax, they do pay interest on it, and generally when you draw down a certificate of deposit, the interest follows the certificate of deposit. It's not any particular rate of interest, it's what the clerk has been able to earn on that interest. If this bill has the meaning that Senator Peterson implies, there is a second check that has to be written in addition to the deposit in every case, because the interest will not match the judgment rate. I don't believe that's what the bill says, and I do believe that substantially complicates what you're to receive.
All right, thank you very much.
Can I make,
Why don't we hear from the rest of the opposition, and then we'll circle back. And I think maybe Mr. Dix is here to say something on behalf of the circuit court clerks. Yes, ma'am.
Katrina Jones-Robleski, Columbia Gas of Virginia, we also oppose. Thank you.
All right, thank you. Chip?
Sure. Mr. Chairman, Chip Dix on behalf of the clerks. And as Mr. Russ indicated, there is a wide disparity about how clerks handle this. And in many cases, they're not able to earn interest on their accounts. So I just expressed that concern.
All right. Senator Peterson, you want to?
I'm going to cede to Josh. This is getting a little bit overly technical for my brain, so.
Yeah, Mr. Chairman, members, if I can clarify something. The interest here, and let me step back, we're dealing with certificates of deposit. The code has two different ways by which property can be taken under the quick take power. One is a certificate of take, and they actually deposit the amount that they say they owe with a certificate of take. Certificate of deposit is really just an IOU that says, at the point in time that we are made to pay this, we will. And so the clerk's offices do not have to do anything about collecting interest. It's not about the clerk's office. What the time period that this deals with is when a certificate of deposit goes in. Remember, that's the IOU. Then time runs, an owner finally gets to a point where they get a verdict or they get a settlement, and it's the condemnor, VDOT, the public service companies, the localities. That's the entity that has to pay the interest, not the clerk's office. And so when
So it's just like any docketed judgment.
that's right, that's right. That's
Okay.
all this bill does. It's not requiring the clerks to collect or monitor interest.
Chip,
Nothing
you
of the
disagree
sort.
with that?
I don't, Mr. Chair, as long as, I'm not sure the language says that.
Well, in G, it says certificate of deposit. Interest shall be payable on funds represented by a certificate of deposit. Right?
That makes sense.
Okay.
We all agreement what that says? Okay.
All right.
All right. Okay.
It's the IRS rate. Okay, so the bill is before us. As amended, Senator Peterson
move to report it.
moves to report the bill as amended. Is there a second?
Second.
It's been moved and seconded. Roll is open. Does this need to go to finance? No? Okay. Can you take the, one chair, I've got one last.
Ayes 10, noes 2, abstentions 1.
17, yeah. 1421.
Mr. Chair, is that all these are? Back there.
We have one final eminent domain bill, and that is Senate Bill 1421, which is offered by our chairman, Senator Obenchain.
Mr. Chairman, Senate Bill 1421 does a number of things. First of all, it deals with situations in which condemning authorities enter property to take surveys. It provides landowners with more notice in advance of these surveys, and requires payment of damages in the event that that damages occur as a result of activities that are taking place during the survey entries. Second thing that it does is it makes clear that proper evidence of the remaining property's value is taken into consideration in making judgments in eminent domain cases. Right now, it's in some courts, there's some question as to whether it's simply the value of the property that is taken. If you take a corner off of a piece of property, that may be the sum and substance of the damages that have occurred. There are questions as to whether should also consider the damage to the remaining parcel of property that's been damaged by the removal of that property, and this makes it clear that that may be taken into consideration. And finally, the bill clarifies current law on what happens when the government abandons the taking or changes the rights it's taking during the middle of an eminent domain case. And in some of those cases, the landowner has had to incur the expense of retaining an expert who has spent considerable time working on the initial claim. And when the government changes that claim or abandons part of that claim, the landowner is stuck with those expert costs and expenses. And this simply makes it clear that the government or condemning authority is responsible for reimbursing the landowner in that circumstance for those expert costs and expenses. So that's the bill.
Does any member of the committee have any questions of the senator on his bill? If not, we're here for those that may be in support. Yes, sir. Step up very spryly, please.
Mr. Chairman, members of the committee, we fully support this. This bill does, as Senator Obenshain said, a number of different things that are helpful to owners in these eminent domain takings cases. The first part is giving notice of who is coming on your property and what they'll be doing. Right now, the statute is fairly broad-based and allows any number of folks to come out with just a very modicum level of notice. This would require the actual names of folks and again, what
that's stated in the bill. Tell us what we don't know.
There are a number of other things here that Senator Obenshain's outlined here. The changes to the project, this is occurring fairly often, that an owner basically subsidizes a plan to put less impact on their property by these takings and are left with enormous bills that right now are not compensable or reimbursable. And so this bill will do a number of things to close some loopholes there and better protect property owners' rights in these cases. Thank you.
Thank you very much, sir. Yes, sir.
Mr. Chairman and members of the committee, I'm Stephen Clark. We asked for the committee to support this bill for the reasons the Senator Obenshain outlined and my colleague Mr. Baker outlined. But I want to talk about the fairness aspect of this bill, and particularly the amendments to or clarifications of existing laws to what evidence is admissible as far as damages to the remaining property. That is a really critical aspect of a lot of eminent domain cases, certainly for my property owner clients. A lot of times that's where the rubber meets the road in the cases. And ensuring that evidence that the marketplace would consider, that private parties would consider in their transactions that they're buying and selling property is also admissible in court. When the court is setting and a jury is determining the compensation, we think that's appropriate, and so we ask for the committee's support. Thank you.
Thank you, sir. Good morning.
Good morning, Mr. Chairman. Nicole Riley with NFIB, representing about 6,000 small business owners, and we support this legislation, particularly those aspects that would take into account the costs that have been incurred during a taking for a lot of small business owners. These can be very expensive bills, and making sure that if those takings then there's interruption at some point in the proceedings and those kinds of things, and a plan or project is abandoned, that they still have some avenue of compensation. Thank you.
Thank you, ma'am. Good morning, sir.
Good morning, Mr. Chairman. Steve Rossi with the Family Foundation. And we support this bill as well as a measure of fairness for families, family-owned businesses and farms all throughout the Commonwealth. Thank you.
Mr. Chairman, members of the committee, Andrew Smith, Virginia Farm Bureau Federation, and we support the bill.
Thank you, sir.
Mr. Chair and members of the committee, Katie Hellebush representing the Virginia Forestry Association, and for all the reasons explained, we also support the bill.
Thank you very, very much. Is there anyone who has a contrary opinion in opposition to the bill? Mr. Russ?
Mr. Chairman, John Russ on behalf of Dominion. I want to raise just 3 technical points on the bill if I can. The addition to the notices basically simply requires a statement of the number of persons that are coming. Doesn't require names or other things from those persons. I would submit that the number of persons is not that relevant to the entry, and it simply creates another technical reason to challenge the entry going forward, which we think is unnecessary as we go through. Secondly, if you'll look down on line 53, it requires the recovery of fees for at least 3 experts. If you only have 2, I'm not sure how you apply that. And if you will look over on line 174, this is dealing with the remedies for an amendment or a change to the take that has come in. It basically provides that you will get damages for the amendment, but not for the mistake. The other language basically allows you to recover damages because there was a mistake in the taking. This one allows you to recover damages only for the amendment, which I would submit is the damages that are from the take. So I'm not sure that language is what the patron intends. Those are issues I would raise with the bill.
Thank you, Mr. Russ. Good morning, Patrina. How are you?
Good, thank you. We just echo the comments of the previous speaker.
Thank you for your brevity. All right, Senator Overchain, any closing comments, sir?
All I would say is these are a couple of minor changes. The one that might be viewed as most substantial deals with the damage to the remaining property. And I would just point out that all that does is it codifies a case decided by the Supreme Court in the 1950s. It doesn't change the landscape. This is not a earth-moving bill, but certainly helps property owners and makes the system more fair.
Ladies and gentlemen, the committee Senate Bill 1421 is before you for action.
Move to report.
It's been moved and seconded that Senate Bill 1421 be reported. Any discussion? If not, if you'll open the roll, please, sir.
Ayes 12, no 0, 1 abstention.
Bill's reported. Thank you, sir.
Mr. Chairman, if I may, Senate Bill 1422 is one with a little bit of urgency to it. Like to take that up?
Yes, sir. Direct the committee's attention to 1422, lease agreements.
Mr. Chairman, this is a bill that arises from the decision of the Virginia Supreme Court last year in the Game Place versus Fredericksburg 35 case, which really cast into question the validity of potentially thousands of commercial leases around the state as a consequence of a fairly obscure principle from English common law. There are billions of dollars of investment which are really based upon the validity of these leases that have been entered. What the Supreme Court did was cited the English common law, the statute of conveyances in invalidating a number of leases for terms over 5 years because they did not comply with the formalities required of a deed. It surprised an awful lot of people. I'm not here to suggest that the Supreme Court of Virginia, heaven forbid, was erroneous in its conclusion. However, it works a real hardship, and I don't believe that there's any question that the parties to these leases mutually agreed and believed that the leases were valid and binding, and the decision of the Supreme Court cast into doubt the validity of those leases. This simply makes it clear that the practice that's been observed in connection with the execution of these commercial leases is approved by the General Assembly going forward. These leases will not be required to meet the formalities required of a deed, and those which the parties mutually agreed and understood would be enforceable will indeed be enforceable. So with that, Mr. Chairman, and I would point out that this bill has an emergency clause attached to it, and it is brought as a result of the combined support of a number of organizations, the Virginia Bar Association, the Bankers Association, the Association of Realtors, Virginia Association for Commercial Real Estate, and the Virginia Apartment and Office Buildings Association.
Any member of the committee have any questions of Senator Obenshain on Senate Bill 1422? Hearing none, anyone wants to very briefly speak in favor of, even though we know who stands behind it? Okay. Is there any opposition? It's been moved and seconded that Senate Bill 1422 be passed. Any discussion? Hearing none, open the roll.
Ayes 13, no zero.
Thank you, Mr. Chairman.
Thank you, Senator Obenshain.
Sorry, Senator Peterson.
I have some witnesses here, if it's appropriate to take up a bill, the GDC bill.
Yeah, let's go ahead. 1121.
Yes, sir.
It's a recommendation of the Committee on District Courts, isn't it?
Yes, sir. Mr. Chair, members of the committee, I'll try and be real quick and just throw this to our experts, witnesses. This is a bill that would give Fairfax County a 12th General District Court judge. Just a few very brief statistics, and I do have the chief judge here, Lisa Main, and also Manny Capsalis, who came down from Fairfax County. Fairfax County right now generated 310,000 new cases in 2017, or 11% of the total statewide caseload. Currently, each judge in the 19th Judicial Circuit, which is Fairfax City and Fairfax County, has a caseload of 31,242 per judge, which is approximately 40% higher than the average in the state. We do have all 11 judges filled right now, but we're seeking a 12th. The Committee on District Courts recommended 12, and I know that there was the survey on that. The survey data showed 12. So I do have my experts here, if I could have them speak before.
Senator Norman.
Senator Peterson.
Yes, sir.
We normally act on these bills, but I would just remind you and your colleagues that sometimes there's a disconnect between authorizing a judgeship and appropriating the funds for the judgeship, and that we work very closely on an ongoing matrix that we have based on workload indicators.
Yes, sir, and I understand this is not the money part, and I've told my witnesses.
All right, step right up. Yes, ma'am.
I am Lisa Main, the Chief Judge of the Fairfax General District Court. I did prepare a short briefing sheet, which I would like to pass up if I could. I will say that our presentation to the Committee on District Courts lasted 30 minutes.
We don't have 30 minutes today.
I know that we don't have that kind of time on this occasion. That's why I prepared the briefing sheet. I will address the qualitative factors behind the request. Judge Capsalis will address the quantitative factors. Our traffic, criminal, and civil dockets begin at 9:30 and must end by 2 o'clock in order to begin felony preliminary hearings, DUI non-comp cases, probation violation cases, hot lane cases, pretrial release violations. During a typical morning, one judge is assigned to hear cases in the satellite courts. 2 judges are hearing misdemeanor criminal cases. 3 judges are spread out between the civil return docket, the civil trial docket, and the protective order docket. And that leaves with 11 judges, 5 judges to hear the traffic docket. With only 10, our current staffing, that leaves 4. The introduction of cruiser and body cam video combined with the Supreme Court case requiring breath techs to testify now means the average DUI takes at least 1 hour to try. When you have 150-plus traffic cases on your docket and multiple DWIs included within that, and any one of those DWI trials goes, you're not going to be able to make your 2 o'clock docket. So on a day when the protective order judge is hearing what turns out to be a 5-hour protective order case, and 2 courtrooms have DWI trials that go over, and you have a criminal assault charge with 6 witnesses requiring interpreters, it is a scramble to cover these 7 afternoon dockets. And what happens is things get combined or cases get bumped. And I'm here to tell you, unfortunately, that we have had to bump cases. Judge Capsalis had one recently on our DWI blood docket that at the end of the day just couldn't get to be heard, and that case got bumped. And the risk with cases getting bumped is that witnesses don't come back.
Judge, I've never appeared in your court, but I do appear in Fairfax Circuit Court, and until I figured out what this little card is, I got stuck in the queue outside of the courthouse on a number of occasions with some of your customers waiting to be heard, and it's a pretty substantial line of folks. So I think we understand, and to echo Senator Norman, I don't anticipate any roadblock to passage of this bill through this committee and probably on the floor. And we're going to take a good hard look at the figures that have been generated, and we pretty rigidly adhere to the recommendations that have been made by the National Center. And as Senator Norman mentioned, the matrix, decision-making matrix that we have for funding those additional general district court judges. So just want to impart that.
All right. One point, and if I may pass it over to Judge Katsalas for a brief second. The very issue that you did raise came up in the Committee on District Hearings, and we did debate it. And the report does provide a mechanism to revisit courts that are on the cusp, and we're on the cusp. And I do believe that it was Speaker Cox who said, you have to have a process. That process can't always be no, and based on the evidence, we did get the unanimous vote of the committee that we warranted that seat. But I will pass it over to Judge Katsalas briefly.
Thank you, Judge. Appreciate your being here.
Thank you, Mr. Chairman. Members of the committee, my name is Manny Kapsalis, and I am a colleague of Judge Maines, judge in the Fairfax General District Court. I appreciate the chair's comments a moment ago. We do certainly appreciate this is the authorization part of this. Funding would be down the road. What I would point out, and just to piggyback on what Chief Judge Mayne said, while we appreciate the report that was done in 2017, what we realized was that that was very much dependent on the number of judges you had at the time the report was done. If we had had 12 judges at the time the report was done, it would have said stay 12 judges. If we had 13 judges at the time the report was done, it would have said stay at 13 judges. As it turns out, and I think Senator Peterson pointed out, we currently handle 39% more cases than the average general district court judge in the rest of the Commonwealth of Virginia. And even if we were to be bumped up to 13 judges, we still would be handling more judges more cases than the rest of the Commonwealth of Virginia. We're at a point where it's really reaching critical mass, and we're scrambling to try to cover the cases. This is an administration of justice issue. We want to make sure everyone has their opportunity to appear before the court and have a fair hearing in the court and in a timely manner. That's why we're before this committee, and we appreciate your consideration.
Thank you, Judge.
Mr. Chairman.
Senator
Mr. Chairman,
Stanley.
I have a question for Judge Kapsalis.
Yes, sir, Senator Stanley.
Judge Kapsalis, you're still a general district court judge? Haven't moved up?
That would be correct, Senator.
And how long have you been a general district court judge?
I have been a general district court judge since July the 1st, 2015.
And
before that, I was a substitute judge for 12 years.
Mr. Chairman.
Senator Stanley.
How many judges were there when you were elevated to general district court?
We were approved for 10 judges on July 1st, 1990. We were increased to 11 judges on July 1st, 2006. For a brief shining moment, we did have 11 judges. We're currently at 10 judges. So we're currently at the level that we were 29 years ago, 1990.
And Mr. Chairman. And yet your caseload keeps increasing.
Well, not just the
Percentage-wise?
caseload, but
How much?
also the types of cases and the complexity of cases. As Senator Stanley, you well know, having appeared before our court, the jurisdiction of the court has increased. We're also taking on different types of cases. The county has really been very invested in veterans docket and mental health docket, which we may be embarking upon. And also, we've taken on jurisdiction of protective order matters as well. So it's not just the number of cases, but also the types of cases and also the length of cases. For example, and I'll just give you one brief example.
Please.
The number of long civil trials in our court has increased from, when I say long, more than 2 hours, from 8 to 63 over the last few years. The result is that we've had to schedule these cases further and further out. That's not what we want to do, but now it's a very lengthy process for these.
No, and Mr. Chairman, I'll only say that I know Judge Capsalis because when I was in my 20s and a young attorney, he was my boss, and he fired me. So
For cause.
There was no cause.
I don't think there's any comment I need to make to that.
Well,
I have great affection for Judge Capsalis.
Mr. Chairman, I have a question.
We've spent way more time on this bill than we ever spend on these bills. So,
What was the population of Fairfax County in 1990?
The population of Fairfax County was 818,600.
And
The
today?
population currently is 1,142,900. Those are approximate numbers.
Okay,
right.
thank you.
Anybody in opposition to the bill? No. Senator Peterson moves that the bill be reported. Is there a second? It's been moved and seconded the bill be reported. All right, bill reports. Thank you very much. While this has gone on a while, you will appreciate this later in session that we are making this investment in time as we dispose of these bills. Let's, Senator Chapin, you've got two really quick bills, he says. I know, you've got one too. I know. 1166.
Yes, Mr. Chairman, while these will be really quick, they are both dynamic and critically important to the future of the Commonwealth. So the first one comes to us as a Clerks Association cleanup bill.
And I was prompted to ask you preemptively whether you've ever heard of the single object rule.
I have. This bill simply provides that the blood, saliva, and other tissue that is taken from a defendant in a prosecution for a criminal case that is under state law would also be taken by a similar ordinance of a local government. The second issue clarifies the prohibition that local officials not divulge tax information doesn't apply to tax to an estate probate tax issue before a commissioner of accounts. And the third thing repeals the Torrens system as it's no longer needed.
It's no longer in use.
Correct.
All right. Anybody have any questions of Senator Chapin about this wide-ranging bill?
Move to report.
Is there a second? It's been moved and seconded that this outstanding bill report. And 1186.
Yes, sir. This bill
that reports 12-0.
Is brought by the VBA, and you'll remember just a few years ago we amended 64.2-601 to allow for payment or delivery of assets in an estate under $50,000 by the use of an affidavit and to the successor of those funds. And under that statute, it was designated that the bank would be discharged from liability. While I greatly appreciated that discharge of liability for banks, there needs to be a clarification that that the bank is just charged from all claims for the amount accepted, not just a general discharge.
I move the
And-
report.
Nobody, is there anybody here in opposition?
I have a question, Mr. Chairman.
You want to withdraw your motion or report?
Not really.
Okay.
My question is, what is the
There's
limit?
a
Is there a limit on
motion
this?
properly seconded to report the bill. Any discussion? Senator Edwards, you have discussion?
Yeah, I do. What is the limit on this? Is there a limit?
Well,
I don't see it.
My understanding is the affidavit has to be valid.
But for the amount, what is the amount? $1 million? Is there any
Small
limitation?
amounts.
It doesn't say what the small is. How much is small? $100?
I believe it's $50,000, Mr. Chairman, which is the smallest state.
All right. Motion's been made and seconded to report the bill.
Ayes
All right.
11, no zero, one abstention.
All right, Senator Edwards, 1080. You want to walk us through this bill, or you want Kristen to do it?
Mr. Chairman, I'd like either this bill to go through without any questions
Senate
or
Bill
take a week
10
and read it all.
Senate Bill 1080. Here, Kristen, you want to hold up Senate Bill 1080? There you go. Anybody want to ask Senator Edwards to walk through this bill?
Mr. Chairman, I
This-
have Chip Dix here who's willing to read it all. It'd take at least a week. It's longer than War and Peace, I think.
This bill is a recodification,
Yeah.
recodification of Title 55, which is a multi-year project, my understanding is, of Code Commission.
Yeah, Mr. Chairman, yes, this is a Code Commission bill that took 2 years with extensive work with the interested parties, stakeholders.
You aware of any opposition to the bill?
I certainly hope not.
Anybody here in opposition to the bill? Everybody loves the bill, right? Senator Edwards moves, Senator Peake seconds. I'm sorry. That we report and re-refer this bill to the Committee on General Laws.
Yeah. Yeah, legalize it.
Ayes 13, no zero.
Senator Lucas, Senate Bill 1210. And for members of the committee, this is one of the bills on the list of bills that this committee heard last year. It is identical to Senate Bill 987 from last year.
Yes, sir, Mr. Chairman, you have
or
a bill
at least
that's
was.
have a substitute.
All right, there's a substitute that's been distributed. Senator Lucas moves, Senator Edwards seconds the adoption of the substitute. All in favor signify by saying aye.
Aye.
All opposed. The substitute's before us. Can you tell us what the substitute does?
Yes, sir, Mr. Chairman, there are only a couple of changes from last year, but as you know, 1210, Senate Bill 1210 is born out of the violence we saw in Charlottesville in 2017, and a significant rise in hate violence and a threat posed by trained and organized militia that are growing all over the Commonwealth and, as a matter of fact, all across the country. On the streets of one of Virginia's cities, we saw organized, trained extremists armed with powerful weapons marching through our streets. Interviews with leaders of these groups revealed that they were operating as unregulated, uncontrolled, unaccountable, self-appointed so-called security forces. Their appearance and their power of their weapons greatly increased the likelihood of greater violence, confusion, and even large-scale confrontation with legitimate law enforcement authorities. According to Thomas Cullen, United States Attorney for the Western District of Virginia, he said, over the last 10 years, the majority of extremist killings in the United States were committed by militia, white supremacists. At bottom, we have too many white supremacists in this country. They're becoming increasingly organized, militant, and violent. And until we take some concrete and immediate steps to deal with that, we're going to be, unfortunately, continuing to talk about these problems. Excuse me. Current law only prohibits teaching and training with one or more persons to demonstrate how to use, apply, or make a firearm, explosive, or incendiary device, or a technique capable of causing injury or death if the purpose is to use these skills in furtherance of civil disorder. Senate Bill 1210 enhances the current prohibited paramilitary activities statute by providing that a person is guilty of unlawful paramilitary activity if they assemble with another person or persons with the intent of intimidating one person or group or other groups with any firearm, explosives, or incendiary devices. Senate Bill 1210 tracks currently existing criminal law in 18.2-423, cross-burning with intent to intimidate, and 18.2-423.2, displaying a noose with intent to intimidate, which were upheld by the U.S. Supreme Court, the Virginia Supreme Court, and the Virginia Court of Appeals. Like those statutes, Senate Bill 1210 criminalizes only true threats, and intent to intimidate means that the person communicating the threat directs the threat to a person or group with the intent of placing the victim in fear of bodily harm or death. The Constitution does not permit people to threaten or intimidate others who do not share their views. This bill will help prevent future violence like that we saw in Charlottesville, in addition to sending a message to any group that elects to assemble in order to intimidate others. And Mr. Chairman, members of the committee, if you have any questions, I have some backup assistance from the Attorney General's office.
So, okay. Any questions of the patron? We'd be happy to hear from the Attorney General's office.
Matt?
Morning, Mr. Chairman. Matt McGuire, Principal Deputy Solicitor General on behalf of the Attorney General's office. The Attorney General supports the bill. I'd be happy to answer any questions the committee has.
All right, thank you. Any questions? Bill is before us.
Second.
All right, it's been, yeah, it would have to go to the Finance Committee. Is that your motion? All right, motion has been made, properly seconded to report and re-refer to Finance.
Ayes 8, noes 5.
Okay.
Thank you.
Yes, ma'am. And I've got one last bill, and we'll have gone through the entire docket. If I can do it from here.
Yes, sir. Senator Openchain, Senate Bill 1426.
Senate Bill 1426 deals with kind of an antiquated feature of Virginia law. Virginia law actually has a provision in 64.2-409 that allowed clerks to accept for safekeeping wills. So if somebody signed a will, they could go lodge it with the clerk. However, there were no indexes, and nowadays, seldom is that ever done, and clerk's offices around Virginia have dealt with these in a variety of ways. I know one clerk's office that has hundreds of very, very old wills that have never been collected. Other clerk's offices, anecdotally, have had hundreds of old wills, but mysteriously, they are there no longer.
Mr. Chair, does this mean Fairfax County has to destroy George Washington's will?
Yeah.
I don't know. No, it does not. It says that the clerk may destroy. And if the clerk of Fairfax County decided to do that, I suspect he would not be the clerk of Fairfax County much longer. So with that, all this does, and this went to the Trust and Estate section of the Virginia Bar Association, and simply allows the clerks to destroy these writings if 75 years has passed.
Any member of the committee have any questions of Senator
Yeah,
Obenshain?
Mr. Chairman, I have a question.
Excuse me,
Mr. Chairman.
Senator Edwards.
If I did a will when I was 18 and I'm now 99, there's a chance this will could have been destroyed. My only will
Yep.
is now destroyed, and I'm not yet dead.
You want to change it to 100?
Why don't we do that? I move to make it 100.
It's been moved and seconded by Senator Deeds that we amend it to reflect 100. Any discussion? All those in favor of the proposed amendment signify by saying aye.
Aye.
All those opposed, the amendment is adopted. Is there a motion to report?
So moved.
It's been moved and seconded that Senate Bill 1426 be reported as amended. Any discussion? Hearing none. All those in favor, please note your vote.
You better know.
Ayes 11, noes 2.
2 noes.
All right, with that, we have disposed of about 33 bills, so the committee will rise.